to respect everyone's time. Good morning, everyone. It's good to see familiar names back today for day 2 of our domestic violence training. For those of you who were here yesterday, I know that you are anxiously waiting to hear about day 2 and building upon the wonderful information that we learned and that we're growing with for domestic violence. So as we all know, October is Domestic Violence Awareness Month. And in the spirit of us working together and growing together to become better, learn more, and to be the best that we can be for our communities, we are here training together. And so we're going to continue to build on that. I'm going to have David and John again introduce themselves and give their background for those who may not have been here yesterday to hear about their background and where they come from. So David, I'm going to go ahead and turn it over to you and we'll get started shortly thereafter.
Hey, thank you, Alicia. Dave Thomas. I am presently working for the International Association of Chiefs of Police, and I've been with them full-time for about 5 years now. But I started working with them in 1999 when I was an officer on the Montgomery County Police Department running the domestic violence unit. I started the first domestic violence unit in the state of Maryland back in '97. And once I left Montgomery County, I went and did a stint up at Johns Hopkins University in the Division of Public Safety Leadership program, in which law enforcement officers, supervisors, and above were finishing their bachelor's and getting a master's. And I did all violence against women type coursework. I did a short stint at the Pentagon in the Sexual Assault Prevention and Response Office before coming to Hopkins full time. My career has been spent addressing these issues, and I'm really happy to be here with you today, and look forward to training and hopefully getting some interaction with you all today as we address this issue.
Thanks,
John.
Dave. Hey, I'm John Wilkinson. I'm an attorney advisor with EquitasS. EquitasS is the prosecutor's resource for state and local prosecutors' offices across the country on a variety of crimes. We focus particularly on domestic violence, sexual violence, stalking, human trafficking, any violence against women issues or gender-based violence issues. We also run the Innovative Prosecution Solutions Grant, of which the Rockdale County DA's office is one of our grantees, and that's how this training is being brought to you because Alicia was able to get, along with us, get Dave Thomas to do this training. And I think those of you who were here yesterday sort of saw that great sort of foundation that Dave laid for about how these crimes work. And then once you get that, if you weren't here yesterday, you didn't, it's not like you missed out, and that's recorded, and you will be able to watch that anytime you want. But it does sort of, once you get how these things work, everything else kind of starts to fall into place, I think. And then Dave's gonna talk a lot more about how we approach these cases as we're going forward. So my background is I was a former assistant Commonwealth's attorney in Fredericksburg, Virginia. That's what we call the prosecutors there. And we were a small office. There were only 4 prosecutors in our office. We were a small town of about 25,000. And it's about an hour south of DC. But so because it's a small office, you do everything. Like I prosecuted everything from traffic offenses to first-degree murder. But I focused a lot on domestic violence, homicide, sexual violence, and I was on our sexual assault response team, which was kind of what was a game changer for me, because working closely with advocates and police and medical, you just started to learn, like almost involuntarily, like you don't even realize you're learning, but you're just starting to work regularly and closely with folks who know how these crimes work. And so it helps you start to advance. We would sit and meet once a month and talk over the cases, and you just suddenly start learning, oh, these victims behave a little differently than my victims in other cases. And all I have to do is strategize a little bit, and I am going to have more success, and I'm going to understand and do better investigations and charging decisions and things like that. So that was a big change for me, and I encourage folks to work collaboratively like that, because I know it's helped Dave, it's helped me in my career. And we just talking about yesterday, I've probably seen Dave do that presentation 5 or 6 times now, and there's always something new I learn, and it's just great information, and I'm sure we'll have the same experience today. So with that, I'm going to turn it back over to Dave. If you guys have any questions as we're going along, feel free to chat them and we'll address them as they come up. If you prefer to wait to the end, that's fine too. But don't hesitate to reach out as we're discussing something, because I'm sure other people have the same question in their head. So please feel free to chat. All right, Dave.
Thank you, sir. Yeah, please go ahead and send them in the chat. You know, there's no time like the present. So if you've got a question, shoot it out there. We want this to be as informal as possible, doing it virtually. You know, when looking at this, one of the reasons for nuances in addressing domestic violence calls, intimate partner violence calls, over the last 20-25 years especially, is because of a recognition of the nature of these crimes as being the crimes that they are. You know, when I first came on in 1986, they were still considered a private family matter. That's the way we in law enforcement were even trained. We didn't recognize them as the criminal acts they were. We didn't effectively recognize them as the criminal acts they were. It was almost like the law stopped at the doorstep. And what I mean by that is that, you know, an assault that happened at the corner bar, we had no problem locking somebody up. But if you had the same type of assault in a private residence between a husband and wife, we weren't recognizing it for the criminal activity it was. And that's why, like yesterday, I talked about having to see these crimes as the crimes they are. When you hear carjacking, when you hear drug dealing, the automatic default is these are criminal acts. The same has to hold true here. And so what was recognized in the late 70s, early 80s, we started to really recognize a need for change in the way that everybody in the criminal justice system addressed these crimes. It wasn't just law enforcement, it was prosecutors, it was judges. Advocates had been telling us that forever, but we weren't listening. We weren't listening partly because we weren't effectively collaborating with the advocacy community. We weren't even effectively, in many cases, especially in this category of crime, we weren't effectively collaborating with prosecutors. And it's when we started collaborating, started learning more, that we started to change. And you know, the goal of the change is to have that effective response, which meant, bottom line, is making the law keep its promise. And the primary focus being the promotion of victim safety. And I'm going to talk about it a little bit more in a little while when we talk about lethality assessment. But if you don't realize it now, you really need to come to grips with the fact that victim safety is officer safety. And I'm going to show you exactly why. The research, the statistics bear that fact out. These individuals who kill their significant other, they kill third parties, they kill us, and they are responsible for a large number of officers annually who are feloniously killed year after year after year, upwards of 30+%. So this individual is a danger to everybody involved. And so we need to stop the violence. We need to make certain that we're keeping victims safe, the community safe. And we also need to make certain that the individuals who commit criminal acts are held accountable for their criminal acts, just like any other crime out there. And we really have to realize that successful prosecution is really seen as the avenue for preventing future acts of violence, for preventing these misdemeanors from graduating to the felony. And by that, I mean, you know, when I first came on, we were going to the same home again and again and again. Why? Because we were doing the same thing again and again and again. That wasn't working. And so that's where, you know, Einstein comes in and tells us, don't keep doing the same thing and expect different results. We had to change the way we were approaching these crimes. We had to change the way that we were working with community partners, right? We had to get out of our stovepipes, start talking across professions and really working effectively together, because when we weren't doing that, it benefited no one except for the perpetrator. And consistent with criminal prosecution, it sends a message that violence in the home is criminal. It's criminal behavior that won't be tolerated, plain and simple. And we have to not only articulate that, we have to, by our actions, show that that's the way that it's gonna be approached. San Diego, California is one of the first places that really study this to try to see what's going on and try to see what kind of changes need to be made in order to keep victims safe, victim and their family safe, keep everybody safe, really, and hold perpetrators accountable. And a lot of this was under, at the time, Casey Gwynn was the lead prosecutor there, and in his office was Gail Strack. And so what they found once they studied what was going on there, that the prosecutor's office didn't have a comprehensive prosecution protocol for these cases. It was kind of hit or miss the way that they were dressed. People were in stovepipes, as I mentioned just a second ago, and stakeholders were not working it together. They didn't realize that in order to better address these cases, in order to have that safety factor and to hold people accountable, you had to have a seamless type of approach. And by seamless, I mean, if something's not seamless, there's going to be a leak, right? And we know criminals time and time again get off on technicalities. They get out, they weasel out of things in any way they can. And so having a seamless approach means that we're shoring things up and making certain that there aren't those cracks and those spaces for people not to be able to be held accountable. There was a lack of a charging protocol. Once these cases weren't consistently handled in the same way, and there was a lack of expertise in offender dynamics. We did not know the offender, this category of offender. We didn't recognize what better attributes were. We didn't, this is before power and control. You know, power and control was developed up at the Domestic Violence Abuse Intervention Project under Ellen Pence. And they, in working with victims of domestic violence, started doing research really on what were consistencies found in these women who were in a relationship in which they were being, they were domestic violence victims. And so that's where all the tactics on that power and control wheel was born out of. It was born out of the real life experiences of victims of domestic violence. What was consistent in these relationships? But prior to that, there was a lack of expertise in knowing these. We were just kind of going out blindly addressing this stuff. And so, you know, a lot of this training yesterday, today, a lot of what we're pulling together is finding out what we need to look for and what we need to listen for in order to effectively address these cases, right? And so all of these things is what San Diego started to address when it came to developing an approach to really look at these crimes, to really effectively address these crimes. And that's where they came up with the evidence-based prosecution. It's the prosecution of a case with evidence other than that comes from the victim. And it's necessary because in these cases, one consistent thing that we find, and we find all over the country, is that victims may disappear, recant, minimize, or refuse to participate for many legitimate reasons, right? But if that's a factor, then we have to find out, we need to be looking at how do we mitigate that factor, right? And this wasn't physics. This was addition and subtraction. We looked across, they looked across and said, well, where else in law enforcement, in our investigations, do we do this? Where else do we use evidence to convict the perpetrator in a crime? And the answer was pretty easy: homicides. You know, that's an evidence-based prosecution, right? And what do we have to do? We have to gain all kinds of facts and circumstances, all types of evidence that meet the requirements of the elements of the crime in order to effectively prosecute that individual. And so we started breaking the crime down and saying, what do we need? What are the things that are necessary? What does John need me to walk up and hand him so he can effectively take this case forward and prosecute the perpetrator? Or better yet, what does he need so that when he walks up, the defense attorney is saying, you know what, we're going to plea. You know, he'll tell you, I'm sure, and I'm going to let him comment on this in a minute, this whole up to here, but he'll tell you for sure, you know, in what we found in Montgomery County, and I think what he found down in Fredericksburg, was that you had certain individuals who, once they got it, when it came to the investigator and started building these cases, defense attorneys, it's a small group in these towns, even in Montgomery County, they know the officers and everything. They looked, all the defense attorney looked up and said, oh, Officer Thomas, you know what, we're going to plea. Because they knew the quality of the case that consistently is brought forward. It's kind of like when, you know, in law enforcement, you know, after we've used an informant for a long time, if that informant's information is really solid and we can show it's solid again and again and again, the judge doesn't need to know a whole lot much more when it comes to the credibility of that informant's information, right? And the same thing holds true here, but I want John to bring in on this.
Yeah, Dave, that's 100% true. So in my experience, though, it was a few number of cases that got that attention and got that thorough investigation, just what you were talking about, such that there really was no defense anymore. And officers who investigate away defenses also, you know, because we know how these cases go. And we know what they're going to say, you know, whether, oh, she was drunk, she was this, she was that, you know, they do investigations that investigate those away, and then there's not much choice left for those guys. But there were only a handful of officers who kind of got it. So the bulk of our cases did get tried. And because they weren't investigated in this evidence-based way, you ended up trying a lot. You had a lot of what we would call the frequent flyers, which again were frustrating cases because we had the same victim and offender over and over again. And I was in the same boat. When I didn't get how these work, because I wasn't talking to my advocates, talking to my experienced officers and things. And it's like, well, she's gonna say it didn't happen come time for trial. Why am I gonna put the effort in when I know what's gonna happen down the road? But once you get how these crimes work, and that she's not doing that because she hates me or the police or whatever, it's because of the offender who's pushing her to do that, then it changes my mindset. It's like, I want to get that guy even more, and I want to do more to investigate. But you're 100% right. When we do these cases right, there's not a lot for them to do.
Absolutely. And it's really understanding the nature of these crimes, and the more we, the more we understand the nature, the more we're able to effectively investigate. The more we effectively investigate, in the beginning, crossing all those T's and dotting all those I's seems like a big lift, but as we do it more and more and get better at it, we start to be very efficient when it comes to the time it takes to do that effective investigation. It's kind of like, right out of the academy, going out and doing an accident report. Man, it seems like it's overburdensome and so forth. But after you've been on 5 years or so and you've done these left and right, they become real easy. And that's a very meticulous, detailed report, right? So we've shown that we can do this. And so in these cases, they realize this. They realize that how we needed to process forward, how we needed to proceed in order to ensure that victim safety and abuser accountability, that was our responsibility. Because, the law, when it comes to the law, it's not the victim's law, it's the state's law, right? And we as law enforcement officers and prosecutors are responsible for enforcing the state's law. It's up to us to hold the perpetrator accountable for violating a law against the people, right? And it's not even, the victim should not be, it's not her law. It's not his law in some cases, right? It's the state's law. And that's why the victim doesn't have to go retain an attorney to prosecute him or her or whatever for the crime against them. And when we understand that, we also see why it is impaired, why we should intervene. We also understand what the focus of the investigation should be. How many times do we say, well, she did this, she did that, she did the other? The investigative focus should be on the individual who is reported to have committed the act. Not on the law doesn't say, that the individual, the law doesn't say this is assault, unless of course the person who assaulted was drunk, or unless of course the individual who assaulted was wearing this, or unless of course the victim was in this part of the area. That's not, that has nothing to do, I have yet to see a statute where those are, any of that are elements of the crime. So, and that's part of the smoke and mirrors that the defense and the perpetrator want us to go with, all right? Creating that doubt and so forth, and going with stereotypes that live out there in the community. Our investigative focus have to go to making certain that the elements of that crime are met in our investigation, right? And sticking with that, focusing on that, and going forward. Because in these cases, when you look at it, even though it's supposed to be the state's law, the victim had to place the suspect under arrest. When I first came on, before I could make that warrantless arrest of a misdemeanor assault, I'd say, ma'am, do you want this individual arrested? I put the burden on the victim, right? Whereas if it was an armed robbery, I never went and asked the victim, do you want the robber arrested? Right? The victim had to press charges, not the state. The victim had to be participating. The victim had to sign the complaint. The victim had to testify in court. Time and time again, the prosecutor was saying, well, if no victim, no case, right? And it was because of the way we were looking at it at the time. Look, there wasn't ill intent by law enforcement or ill intent by the prosecutor. We just didn't understand it for what it was. And we didn't know what to look for and what to listen for and how to place it in context so we could effectively take the case forward. The victim had to be credible, free of drugs, alcohol, and criminal convictions. how many of these cases involve alcohol? How many of these cases involve drugs, right? That's not realistic. And by the way, many times the dependency on alcohol and drugs are a result of the victimization that the victim is under, right? So these are all things, these are all that smoke and mirrors that I continue to go back to that help to effectively keep that perpetrator out of handcuffs. And so it had to be recognized and it had to be accounted for. This method of prosecution, it really requires us to search out the facts and circumstances, know what to look for and what to listen for. It eliminates assumptions, requiring critical thinking in evaluating the case. And when I say critical thinking, by that term, I mean it requires us. There's no problem with going with an assumption, and as long as we make certain that we test that assumption, right, to make sure what we think is going on is actually going on by way of being able to find articulable facts and circumstances. So we have to eliminate assumptions in evaluating the case and forming our conclusions. Alibis and excuses are better tested for their validity, and perpetrators are held accountable for their actions. John, anything on that?
No, that's exactly right. And that just helps me so much when we get all that information. And, you know, I've got to plan my case, both assuming the victim's going to show up and be able to testify, how they're going to testify, because they don't always testify the way I want them to. They don't typically testify the way they told you what happened at that scene. And so, and then I have to prepare as if they're not going to testify. So I've got all those things going on. The more information that you provide me, I can map that out. So I know I've got a way to get to guilty no matter what happens with regard to the victim, because you've done that foundational investigation that doesn't rely on them being there, or if they are there, it doesn't rely on how well they testify. So all of those things are going to help me go forward in these cases. And it is tough. Sometimes you get judges that push back when the victim isn't there, right? So the more I can go forward on these cases and demonstrate to the judge, I can prove this case, it's my case, I'll try it my way, I'll call the witnesses I want. I mean, I don't want to get into a fight with my judge, but I want to make sure they hear this over and over again, and then they'll start to get it too.
Absolutely. And so, you know, I mentioned it yesterday, and it's worth mentioning again. You know, we know the overlapping nature of abuse. You know, when we talk about one type of abusive behavior in an intimate partner relationship, we need to think about the other ones, because at least half the time those other types of abuse are going to be are going to exist. And this is where we have more charges, and this is not piling on. Okay, stalking is not a lesser included offense of assault and battery. Strangulation is not a lesser included offense of stalking. All right, these are separate charges that should be made if they are going on. And you know, maybe we're called there that evening or that day for the domestic violence, and it doesn't mean that stalking happened at the same time. Did it happen within the statute of limitations? Right. That's what we're asking. But because of in these types of crime, there's usually a course of conduct that goes on, right? Which means there's all kinds of those tactics and behaviors and actions that individual, that the perpetrator is engaging in against their target, against the victim, you know, that you see on the power and control wheel. And we want to see what of that is present, and hold that perpetrator accountable for any and all of those abusive behaviors. But, you know, the research tells us again and again and again, it's been consistent over the last 30 years, where at least half of the time, that batterer who's physically abusing their significant other is also sexually abusing them. If there's kids in that home, half the time they're being physically abused, and we know that 100% of them are being psychologically abused. That 32% of those kids are also being sexually abused. And where there's elders in the home, those 65% of the time they're being abused. Half the time we're also going to see animal abuse. And so that's where, as I mentioned yesterday, our investigative focus should not only be on the crime that we've been called there for that evening, but we should also be doing an investigation incidental to the investigation that we're there for now, just like we do a search incidental to arrest, and at least be asking about those other crimes. Victims aren't going to necessarily volunteer this information. The advocates will tell you that. And that's why collaborating with the advocacy community is so important. So sometimes the victim may tell the advocate and give the advocate permission to tell law enforcement. All right. And sometimes, due to working with the advocacy community and learning from the advocacy community, we're able to really do things in a way that that victim trusts us that much more. And we are then able to get that information from the victim.
Hey,
But,
Dave,
yeah, go ahead.
real quick, I love that search incident to arrest analogy. I just think that's so powerful. It just makes so much sense to me. But we got a comment in the chat, just talking about someone who was working in Tennessee before they came here. They used the LAP, which was a high-risk DB lethality assessment, and it's based on the lethality assessment you're going to talk about. But they just talked about that, and that they would share that information with the prosecutors, and along with the incident report. And I just wanted to share that if you wanted to respond to.
Yeah, that LAP is, I tell you, it's great information that adds facts and circumstances that can be presented to the prosecutor. The LAP. And some people, I've had pushback with the LAP or any type of assessment, threat type of assessment, and say, well, we don't have time. Really, in the course of a good investigation, you should be asking those questions anyway on a routine basis. I was actually a part of the team that developed the LAP in Maryland in 2004. Along with Jackie Campbell and Maryland Network Against Domestic Violence. So I'm extremely familiar with that. And we're going to talk a lot about that in a little while, but those types of questions really help put things into context and give us a picture of what's really going on. In these types of crimes, it's important to realize, that we as law enforcement really are sworn to make the law keep its promise and keep our communities safe. And the prosecutor's responsibility is really to see that justice is accomplished, plain and simple. And so we have to work hand in hand in doing that. In these cases, it's important that we start off on the right foot. First responders are critical due to the fact that victim and witnesses in this category of crime, victim and witnesses often recant or disappear. And, I could go into a whole training on why they recant and why they disappear. It makes sense given the context of the life that they're living, right? Once we peel back the layers of all that's going on and all they're trying to do in order to navigate their situation, it makes sense that they may not show up for a trial, or they may change their story. When we are able to have the time, and John's mentioned it yesterday, he mentioned it today, and the facts bear out that that perpetrator has a lot more time to work on that victim between the time we lock them up and the time we get to trial to work on that victim, to get the victim to recant, to work their magic and say whatever they have to do in order to get them not to go to trial and things like that. It's amazing as many show up as do show up, to be honest. And that's another reason why the evidence-based approach is so important, because this happens so often, and it happens for reasons that are beyond our control, and therefore we have to be able to account for it. Injuries will fade or develop later, and that's why we really need to not only initially get photographs, but get photographs on an ongoing basis as injuries ripen. And damaged property is going to be repaired or left at the scene. And that's why we've got to, we've got to be taking photographs. We've got to document things. We've got to make diagrams of the scene when we get there. The first few hours of this investigation for a domestic violence call are really analogous to the golden hours in emergency medicine. Victims will usually tell the truth on the scene when they're in that excited state, right? Children will usually talk at the scene, and talking to children is important. Talking in a way that child can be able to share information with us. And I tell you, it's worth your while if you have a youth division or child crimes investigative unit, child abuse investigative unit. It's worth your while to go ahead and mirror, one of those investigators when it comes to the way they investigate those crimes and the forensic interviews and so forth, so that you can be able to conduct those types of investigations that involve children. If you don't gather the information in the first 48 hours, it most likely we'll lose it. We got to get it early on because of the nature of the way these things work. And because, in these types of crimes, think about it. How many other crimes does the victim regularly interact with the suspect after the crime is over? And because of the nature of the crime, that's why these things are so crucial. And that's why, in these crimes, that predominant aggressor determination should be standard operating procedure. We should be assessing to see if self-defense was a factor, whether or not someone who in the relationship is the most ongoing danger to the other, each and every time. And so it's really important that when we're, there are ways that we can really tighten up our case. There are ways that there are facts and circumstances that we might not normally capture that are little tidbits of information that really make sense. Many times when we go to a scene, a domestic violence scene, and we get there and we start talking to the individuals, pretty quickly we determine who the victim is. Do we document how we came to that conclusion? Is that in our narrative? That how we came to that conclusion, don't assume that that's not important. John will tell you that that is important. What condition was that victim in? Right? And we don't say they were neglected, they were injured. We want to describe what made us come to the conclusion that they were neglected. We want to describe their injuries, articulate the facts. It's kind of like when we use force. We can't just say, if I go hands-on, if I shoot somebody, I can't just say, well, I shot him because I was in fear, right? I've got to lay the facts on the line. The individual was coming at me with what I determined to be a weapon in their hand, and I gave repeated verbal commands, and the victim continued to come at me. I took the knife and raised it up and all of this, and I'm going to articulate all of that. But I was in fear, I ain't gonna get it. We have to articulate it. We have to lay the facts on the line. The victim's hygiene, right? What was their hygiene? All these, breaking down everything that we see about that victim, how the victim behaved. Yesterday we had a question that went to, the victim was upset. Well, how did you come to that conclusion? I believe the victim was upset, but that's an opinion. We need to know all of those factors that made you form that opinion, right? And that's part of critical thinking that I mentioned earlier. Does it appear that they need medical attention? How do you know? A lot of times, on these cases, they do need medical attention. And by the way, when they're in that state, when they're traumatized like that, they're not a good judge as to whether they need medical attention or not. Go ahead and make the decision to start fire rescue and have this individual checked out, especially if it's a strangulation case. If they mention hands around the neck, objects around the neck, it should be SOP that you automatically get fireboard en route to check this individual out. But all of those things we want to know, we want to document, right? What that individual was saying when we arrived on the scene, and we're going to talk about the nature of these statements and that victims make, that suspects make, and why, because when we put things into context properly, why they'd be admissible later in court. Any comments on these, John?
No, this was great stuff too. And it just makes me think when you were talking about interviewing kids at the scene, I definitely want that information. You guys, I think, are going to gather a lot of information. Some of it I'll be able to use and get into trial. Some of it I may not be able to, but all of it helps inform me about what's going on in this case, how dangerous this individual is, maybe what kind of offer I'm going to make, or I'm not going to make an offer because it's too dangerous. Child witnesses are also, sometimes I will call a child witness, sometimes I won't, just depends on the circumstances. But if I don't know this information, I can't call them, and I can't strategize my theory of how I'm going to get that evidence in. So all of that stuff, the more I know, the more I can figure things out. And even if I don't use it at trial, I'm using that evidence to inform me about the case. Alicia,
if I may, I just want to, I have to articulate how strong that was, John, because like you said, we may not use it at trial, but what the ultimate goal is safety, victim safety. And those children are telling the truth. We know that, right? And so for you first responders to be able to get that information in real time and to be able to document that for us before things get, move on in the process, it allows us to really look at that lethality and understand how shall we proceed for the ultimate safety of the victim and those children. So I had to just go ahead and chime in on that. Sorry, thank you.
No, that's excellent. Thanks.
Well, and for both of you, I think it's also important, even though it may not be admissible at the time, sometimes the defense throws stuff out there that they basically throw you almost a lifeline and make this claim, and now you can use it to impeach what was said, this ridiculous claim that's made by defense, because they didn't know you had it, because at the time you can't use it. But if they make a wild claim, you can use it. Am I right?
Absolutely. That just knowing that more stuff is gonna help prepare me for whatever they come up with. And I kind of know what some of those defenses are going to be. So when I have that information, I'm like prepared. I'm prepared. I'm not.
I have to add this part too. In speaking with that child, if you would get their full name, at the time, get their full name, their date of birth, and who they live with, if you can as well, because that'll help us to be able to locate them at a later time.
Yeah, because those witnesses have a habit of parents suddenly they're going to spend the summer at their grandparents, or, we're not going to be able to locate them. So getting that information is helpful.
Well, and their credibility, establish their credibility. There's a few questions you can ask at the very beginning. How old are you? When's your birthday? All those types of things. When's your birthday? They give you your birthday. Is your birthday next week? No, it's not until November, as to saying yes, yes, yes to everything that you say, right? And so you can establish those little things, because the defense is going to try to say, well, the kid's not credible. They're only 6 years old. You can establish that by asking questions to show you that they know what's going on. They do have a presence of mind, little things to establish that. And then, and like Alicia said, they're telling the truth. They don't have the cognitive ability to think through things and make up crap. They just don't.
Not at that point.
Even if they wanted to.
Yeah.
So that's all smoke and mirrors. That's all Hollywood. That's not in the real world. So it's really important. When it comes to that suspect, why do you think this is the suspect, right? Most times we are right. Most times when you go on a scene and you're training and experience it, there are things that you recognize that tell you this is the suspect, right? Note those things. Those things are vitally important. Do they have any weapons? What are they doing? What are they saying when we arrive on the scene? What are they saying to us? What are they saying to other people on the scene, right? What are they saying to the victim, to anyone else at the scene? This is where body cams really come in handy, because there's so much that even if we're really good at capturing stuff, we miss stuff that they may say and everything. And we're trying to document everything, but we got a lot of other stuff going on. We're trying to make the scene safe. We're trying to keep track of where everybody is, all of that kind of stuff. So, but all of this is important. What is his condition? Is he injured? Is he complaining of injury? Because later on, defense might say, well, he was injured too, but the officer never asked about it, or things like that, right? So we want to make certain that we cross that T, dot that I, that I. We want to make sure that we note all these things. Is he making any threats in front of us? And that information is important, not only to be documented in the report, but it's important later on if we make an arrest to let the commissioner know, to let whoever know who is going to set bond or bail or anything like that. Anything on the suspect, John?
Yeah, no, that's also great. Just the more get them talking, whatever they're going to tell you, we're going to be able to use, pin them down. Things like that. I really like the focus on injuries, because I've had cases where they have injured themselves post incident and claimed it was part of the incident. And it's just, those common things, you're just, again, eliminating defenses. And it just, I hate to feel like I'm a lazy prosecutor, but it makes my job so much easier when you do those things, because now I don't have to worry about any of that stuff. Because you've done it all up front and gotten it all out of the way.
Absolutely. We want to, with the children, what condition are they in? Are they safe? We want to, just like when we're documenting the condition that victim's in, we want to document their condition. Are they trembling? Do they look, are they scared? Do they have an expression on their face that makes it look like they're scared? And we're going to follow that up by asking them, what's going on? How you doing? Can you tell me? Are you upset? Things like that. Elders on the scene, what condition are they in? We want to talk to them. Do they seem to be safe? And we need to determine that by talking to them. Pets, what condition are they in? If they seem to be cared for or uncared for, why is that going on? Whose pets are they? Are they the kids? Or are they his hunting dogs? Are they, all of those things in the context of what's going on here? all of these things really can be significant. We want to look at the condition of the property, right? Yeah, an individual has the right to break their own stuff, but what we find is if you see things destroyed, they're probably going to be something that means something to the victim and the kids. He's not breaking his stuff. Like I said yesterday, he's not storming into the garage and kicking his Harley over, right? You can tell this is one aspect of this is a little dated because there's probably no phones in the wall to be ripped out, but things of that nature. What's destroyed around the home? Are there holes in the walls? Doors kicked off hinges? Is there food in the house? What do things look like? Do things seem to be kept up, right? We want to, when it comes to interviewing, first and foremost, we have to make the scene safe, get everything settled down. When we interview that suspect, it should be out of sight and sound of the victim, where safety permits, of course. When possible, we want to interview the suspect following the interview of the victim, so that the investigator has as much information as possible going into that interview. With safety, we want to ask that individual to be seated, and if in a restless state, continue to de-escalate. I always like having the individual seated and being able to stand in front of them, standing up. I want to be in a position of advantage. It's real easy to sit them right back down if they try to get up and things like that. And so we're doing that in as safe a manner possible. They're gonna try to justify their behavior. They're gonna try to say things and get you to sanction their behavior. And while we can certainly acknowledge the suspect's frustrations and concerns, as well as their anger, we don't want to fall into the trap of sanctioning them. They're going to say, man, you got to understand this, that, and the other. And we don't have, yeah, man, you're right. We don't need to go there, right? That individual's looking for you to collude with them. And we don't want to go there. We have to remember that these individuals are master manipulators. And they will do what they can in order to spin us, to send us out the door. We really want to discreetly note statements that these individuals make, especially what's known as a res gestae statement, which Black's law defines as, quote, statements which, because of their intimate relation to the facts, become part of those facts and therefore admitted as such. And what's a res gestae statement? A statement such as, quote, the way she's crying, you'd think I tried to punch her lights out. All I did was choke her a little bit. What's the harm of that? I don't have to make these quotes up. That's an actual quote that a suspect made in a case, right? That's a res gestae statement. It was made right after the fact. It was made on scene and everything. That's an admissible statement. Two things about these statements, okay? They must be voluntary in nature and in no way at the urging of the officer, right? So you want, and when they're made, we want to be discreet in the way that we document it, because the perpetrators, they're not all dumb. If they see us copying stuff down, they're going to shut up. Comments on that, John?
No, yeah, 100% agree with that. But again, capturing those statements, body worn cameras obviously help with all that, because then you don't have to do anything. And capturing all those statements is so helpful, because I'll argue the reason the hearsay exception for why it should come in potentially. With defendants, it's not as big a hurdle, because it's it's potentially an admission. And so usually those are going to come in. Sometimes the victim will give us statements that the res gestae exception is really important, and we might not have another hearsay exception to get it in. And so be thinking about that is also going to be really helpful when it comes to victim statements as well, because that might be the hook that gets that victim statement in as well. But also with those defendant statements, one other thing, when you were talking about ripping the phone out of the wall, because it's the same thing for me, that's because I'm older too, and it's just like that was the thing. But the thing I like about those charges or that evidence is now it's the smashed cell phone, or I took the cell phone away.
Yeah.
Is that interfering with someone's ability to call 911 is a crime, and it's a crime that doesn't necessarily require that much on the victim to testify. Violation of protective orders, all those other crimes that we can prove without the victim's involvement, I think are super important, because I want to get a hook in these guys one way or the other. And so documenting those things, again, it's going to be super helpful. It can help me expand thinking. And usually it's the officers who are helping me expand my thought process about what I should charge. Officers are also great at helping me create my theme for my trial, because they were there and they saw it, and they'll say something about how pitiful this was, or how awful it was, or how I had an officer who, recounting a really awful scene of a domestic violence, he started to tear up on the stand because it was so awful. He thought the victim was dead when he arrived. She wasn't. She was just like ashen gray and stuff. And he apologized to me after he got off the stand. I was like, that was fantastic. That was just like, you are recreating that reality for that jury. And I was just like, don't ever change. I mean, don't cry on purpose, but don't ever change. That was an emotional scene, and it was great. But documenting all those little things is going to create other charges that we might be able to hold that guy accountable when we couldn't for the underlying DV, which sometimes is tougher than these collateral charges.
Yeah, hopefully one of a common theme you're seeing as John and I talk is that the totality of the information, the totality of the circumstances is so key in these cases. One thing standing alone is not going to get us there, but when we start adding all this stuff together, it really starts to bring things into focus and painting a clear picture of what actually occurred. And so recording these statements, knowing what's admissible, often suspects will voluntarily offer statements following their arrests while, many times while en route to the station. I can't tell you how many times putting a person in cuffs, putting them in the cruiser, transporting them to the station, and just turning the radio off and just being silent. And they can't stand it. They've got to say something, right? And that's when we get these spontaneous utterances. According to Black's law, this is, quote, a statement or exclamation made immediately after some exciting occasion by a participant or spectator and asserting the circumstance of the occasion. Like, quote, I wouldn't have pushed her if she had only shut up, or she wouldn't listen, so I grabbed her to get her attention, right? And these individuals, time and time again, make these spontaneous utterances. And for these to be admissible, we know that the officer engaging, well, and then when it comes to admissibility of other statements that an individual may give us, the officer engaging in any questioning has to determine two things. Is the interview or interrogation custodial or non-custodial, right? If the suspect is not under arrest and is free to leave, it's non-custodial. as soon as the suspect is not free to leave, as soon as they're under arrest, as soon as their ability to leave is restricted, it becomes custodial. And then when it comes to what type of questions we're asking, we have to look and see, are the questions being asked to elicit any incriminating responses? If the situation is non-custodial and questions aren't being asked to elicit any incriminating response, Miranda warnings are not required. At the point that the situation transgresses from non-custodial to custodial, or the questions are directed at eliciting an incriminating response, Miranda warnings must be given. We also need to remain cognizant of the educational level of the individual that we're working with, the suspect. And this is really to preclude the defense from claiming that the client wasn't capable of waiving rights due to an inability to fully understand them. John, I weigh in on that to make sure I am legally correct.
Yeah. And I've had that situation, and we do okay on that. It really would have to be somebody who is diagnosed or determined to be someone suffering from particularly low IQ that puts them into a category of a person with, I don't know what the terms are anymore, but a person with mental retardation or something like that. But yeah, I think, again, all of that, knowing when you have to read Miranda and when you do not is so important, because it just is going to get that guy talking more and more. And just always, just do it straight up, and we're going to be fine. And again, sometimes issues pop up, unusual things pop up, and that's also fine. Usually we'll be able to argue against a motion to suppress any statements that the defendant may have made.
Yeah, okay. There's also the excited utterance, which is a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. It's considered non-testimonial, but here timing is really of the essence. The suspect should be confronted as soon as practical. This gives the suspect less time to create a scenario more favorable to the suspect, and at the same time serves to lock them into their story. Surprise suspects are less able to construct mental defenses and alibis. We also want to allow these individuals to vent and get stuff off their chest. Just let them talk. Let them talk. The more they talk, the better. In interviewing that suspect and interrogating that suspect, one question that I used to always like to ask near the end was, what would your wife or girlfriend tell us about what occurred? What are they going to tell us happened? And that's where they go into, well, she's probably going to say, and then they go down to a fact pattern that's close to what really occurred, right? But that's a good question to throw out there, because they tend to stick closer to the truth with what they say that the other person's going to say, as opposed to what they're trying to convince you occurred. One thing that they consistently will go back to is asking who called the police. Tell them whatever you want, but if it's the victim, if it's the kids, don't allow them to place blame for their actions on their significant other or the kids. Tell them whatever you want to, but don't incriminate, even if those are the ones who made the call. That's not something that you have to divulge to them. Many times, the suspect's words and actions really indicate they knew exactly what they were doing. This is important. Information, that I wouldn't have had, I wouldn't have had to ... if she hadn't ... We look at, we were talking about the Petito laundry case yesterday. You know, I wouldn't have had to take her keys if she wasn't so out of control, basically is what he said, right? Right there in front of God and everybody on the body cam. He kept saying, I had to do this, right? I had to do that. I wouldn't have had to set her down if she was, you know, once again, this is not that suspect's child, right? This is their significant other, somebody who's supposed to be equal to them, not in their eyes, but it tells a lot about the relationship and so forth, and their entitlement, what they believe that they are entitled to do. Prior abuse, abusive history, both within and outside of the relationship, can be of key importance. Illustration of whom is utilizing power and control tactics on an ongoing basis, and attempts to corroborate. We need to attempt to corroborate everything and anything, even little things can be vital. And you know, when it comes to that prior history of abuse within and outside of the relationship, that's something that we want to document. You know, the prosecutor may not be able to use it due to the rules of evidence, but if that's where that defense might enter something or try to enter, you know, my client has never been abusive to anybody, you know, this, that, or the other, then we can use it to impeach. Or if the defendant gets on the stand and says they haven't, we can use it to impeach what they've entered in as factual in the case at hand. Questions on that? I mean, anything on that, John?
No, again, I just agree with all of that. You know, almost anything that you can get the defendant to tell us, we're going to get in. We're going to be able to get into trial. So all of this information is going to be good. I really like the evidence that demonstrates a consciousness of guilt. Just little things that they did that, you know, that raise a little red flag in your, you know, a delay in, you know, in cases where the victim is so hurt they can't call, or killed, they can't call 911, and delays in calling 911, little things, cleaning up this, you know, yeah, we had an argument and we broke this, but the broken things are all cleaned up. Little, you know, just little things like that, I think, are super helpful to demonstrate that consciousness of guilt.
All right, thank you, sir. I'm just going to watch this on-scene response to domestic violence calls video.
Has he shot anybody?
He fired a shot. I don't know if he shot or not. And he just choked me. And I'm afraid for my son and my baby. Please hurry, please.
Oh my God! Where are you at?
Victims of domestic violence, they're like a prisoner of war.
Officers have to understand that either you're our knight in shining armor or you're our worst nightmare.
The police are on their way, okay?
The question is, when do we change the culture and all stand up and say that violence against women is something we're not going to tolerate in policing?
Has he shot anybody?
He fired a shot.
Officers have to understand that either you're our knight in shining armor or you're our worst nightmare.
The police are on their way, okay?
The question is, when do we change the culture and all stand up and say that violence against women is something we're not going to tolerate in policing? This is not easy.
Stay there, stay there. I'm coming.
What's easy is for me to sit here and to tell officers exactly what they need to do. I know how hard these cases are.
I need cuffs. Post Falls, we have one male detained. I don't know. She's right over there. Contact her.
Okay, she's bleeding from the face.
Most crime that law enforcement responds to are incident-based. It's a single occurrence, whereas when we look at domestic violence, it's a course of conduct. It's multiple incidents over often extended periods of time.
When a victim calls the police, it may have been the 6th or 7th incident.
Which is really important because I think that when law enforcement come and they see that there's been a physical altercation, there's usually been this whole history of things that have happened before then that don't always rise to criminal behavior, but tell the full story of how powerless she is in the context of the relationship.
Abuser found my mother, and it was my stepfather. And it was emotional, it was psychological, it was really physical. Near-death experiences over and over again over a 10-year period. The officer that came to my house stood on our front porch, and I heard him tell my mother, if we come out here one more time, you're going to jail. And my mother just shook. I mean, and it's one thing for a parent to hold a trembling child. It's a whole other thing for a child to hold a trembling parent. And I never forgot it.
The victim of abuse, who may have used a level of violence in defending herself, who now gets arrested, now what do they think of the justice system as far as being a system of help and a system that they can turn to? And what'll happen is they simply won't.
If you had a cheat sheet in your pocket, here's what you want to do. You want to identify the offender, you want to identify the victim, you want to locate the offender, you want to document your evidence, and you want to find your probable cause.
Do not move, all right?
Yeah, it's okay for her to hit me in the face, right?
We'll get this all figured out in just a minute, all right?
Fuck that.
I like to call this bully determination. Determine in the relationship who's the bully, and you'll have your predominant aggressor.
I hit my wife. I love her more than anything. I shouldn't have hit her.
I know you love her.
I shouldn't have hit her. I shouldn't have hit her.
Was it out of the heat of the moment? I mean, was it a reaction?
It was out of the heat of the moment. After she hit me in the face, I punched her in the face, but my face looks a lot less worse than her face does.
One of the encounters we'll have would be with the perpetrator who plays off as the victim.
She punched me in the face, and then she told Becca to call the cops.
Okay.
I told Becca not to call the cops because it wasn't worth her going to jail.
We've got to be careful to work through that we don't automatically buy the story of one over the other.
You've got to look at the history. You've got to look at what the neighbors have said. You've got to look at the injuries. You've got to look at what the past reports have told you. You've got to look at the behavior of the victim. You've got to look at the behavior of the offender.
She said she tripped over this. There's the phone that's destroyed. Yeah, it looks like it's been smashed with a hammer.
You can't do this in 5 or 10 minutes. This takes time. It takes an investment.
We need to put just as much into a domestic violence call as we do a traffic accident investigation.
I still don't know the whole story. I just got his story, so I don't know what your side is.
I'll talk to you.
Okay, well, you want to go. I just want to make sure the kiddos don't have to hear it, and somewhere where you're comfortable.
They're really approaching it as a conversation as opposed to an investigation where you have to have her standing, you have to have her in a certain room, you have to, do this, but to give her a little bit of autonomy and choice about how this is going to happen is huge.
Just let them know that you're concerned about their safety. The most important thing, I'm concerned about your safety.
My kids have never seen anything like this in their life.
Okay, and they shouldn't. You shouldn't have gone through this, ever.
And you say that sincerely, directly, eyeball to eyeball to that person so that they know. Because the victim is so afraid to tell you what's going on that they will not share with you.
What's going to get at that kind of thing is a conversation, is rapport building, is warmth, is understanding, is time.
How many times would you say over the last 2 years?
A lot.
Can you give me a number, just a guesstimate?
Probably 12.
Have you ever reported it?
Never.
Why not?
It's very scary. He takes my phone. Threatens me a lot.
He always takes your phone when he drinks? Okay, and then he threatens you?
Yeah.
What does he say?
I'll kill you. I'll kill your kid.
If you call the police?
Yeah.
And when we look at domestic violence, we know that often there are behaviors that have meaning only between that victim and offender. And so anybody from the outside will see something and will think it's benign or harmless, but to that victim, it absolutely can be terrifying and threatening.
He used to get a look. Before things like got physical, he would get a look. And you can't describe it. And that's the thing that's really hard to explain to the police too when they're escalating. Well, he got a look. You know, how do you explain that?
Don't be judge and jury in that moment. Just believe her. Let the process take care of itself. One of the most disheartening and frustrating things for people in crisis, particularly victims of domestic violence, sexual violence, and stalking, is feeling that you have to prove the case in the instant of crisis, when that is not what the process is supposed to be about. You're supposed to get help.
Where did, in your face? Okay. All right, I can see your lips a little bloody. And then he said he smothered you with the pillow? Was he sitting on top of you when he did that?
He got the pillow over my face and he couldn't breathe.
Okay.
You're not going to have the perfect cookie cutter victim.
And then what happened?
This victim may be all over the place on her story. This victim may not make a lot of sense because, you know what, this is something pretty traumatic that just happened to this person. And that's the way victim trauma plays out.
As a matter of fact, when she doesn't cooperate, that's evidence. When we see trauma in her, that's evidence. When we see her say, don't take him to jail, that's evidence. When we see the kid say, Daddy didn't do anything to Mommy, that's evidence, because I can get on the stand now and testify that what most often happens in a domestic violence case is the victims are so controlled, they do things completely opposite of other crime victims.
Judge, charge of domestic violence, there's a protection order filed, no victim present?
There is a victim present, Your Honor. She asked to remain outside. She is fearful to come in.
In a courtroom setting, a victim in many instances might, whether the defendant has said anything or not, still be intimidated and be afraid to say anything other than, you know, I just want it to go away.
If we stop at just the arrest, you're under arrest for, and we don't understand how to get to the conviction, we lose. Who do we blame? Do we blame ourselves? Who do we blame? Daggone prosecutors. Damn, they suck. Damn, they get their law degree at. Right? Hell yeah, we do.
I don't know what the emotions were like. I don't know how distressed or calm people were. Only the officer can paint a picture for me of how it was when they arrived.
But writing down specifically what they say versus she described an assault, I saw visible injuries. Statements like, I am afraid of suspect. Specific quotes about her fears, her current emotional state, that can be admitted into evidence.
I'm sorry you had to go through this, okay? And it doesn't matter if you recanted, okay? It still happened, okay? It still happened, and we understand why people recant sometimes.
The more evidence that you can put in front of the court, the more that you can allow the court to see what you see.
Lady did not wish to prosecute at the scene, and the detective signed the complaint. I did.
The more likely it is that the emphasis is going to be removed from just the statements of the victim, and it's going to focus on the totality of the circumstances that surround the event.
This case belongs to the city of Cleveland, not to the alleged victim.
Abusers and batterers can be incredibly creative and incredibly manipulative. And so when we think about the types of behaviors they engage in, it could be really anything, and in some cases, everything.
So often domestic violence cases or incidents involve some level of financial abuse. And that can range from using their credit cards or ruining their credit to putting things in their wives' or their girlfriends' names that they're unaware of. That makes it really hard to separate. Pet abuse is a huge one that we always look for. I did have a case where he killed her dog, snapped its neck in front of her and said, "This is what I'll do to you next time."
Batterers and abusers often engage in stalking behaviors. And when we have that combination of physical abuse and stalking, the risk of lethality for those victims goes up dramatically.
I had emails, I had text messages, I had calls, I had emails from different email addresses. He would send me videos, he would send me pictures, it was constant. It was constant.
Can't give me an answer, Dana? Just give me an answer, please. Scared, terrified. You don't deserve to be hit on and choked and all that. You would rather have me keep calling than to give me an answer, Dana?
Individually, in most cases, those acts are not criminal acts. But when you see them together as part of that course of conduct, then we can start looking at them as stalking behavior.
At least half the time, you're going to also have sexual assault going on in that same relationship. If kids are in that home, at least half the time, they're also being physically or sexually abused. If I don't ask, it's not going to be volunteered.
You're really talking about relationship and building trust, and you want me to tell you the most intimate details of my life that are important because they may save my life if I tell you. But it's very hard to tell to a stranger.
You're laying on your back?
I'm laying on my back.
Okay.
Like both hands on my throat, and he's like lifting his knee up to put it on my neck. And then he started mimicking me when I was screaming.
Take your time if you need to.
The police officer, he just checked in with me constantly. We're eye level. He had his whole body turned towards me. His demeanor, his expressions, he just seemed genuinely sorry at what I had gone through. And I don't know. After all that, to have a grown man be nice, I don't know, it mattered. It was helpful.
On average, it takes a victim approximately 7 times to separate before they completely separate from that relationship.
When you finally get this as a police officer, it's like you've lifted a veil from your face and you can finally see this crime for what it really is. Leaving a violent relationship is not an event, it's a process.
Every little step, every positive response that victim might have with law enforcement can further empower them to leave that relationship.
You have to have patience, and you have to be caring, and you have to provide some comfort to that person. How would you want your family member to be cared for if another officer was responding there? And it's just that simple. You have to think about it as if this is happening to you or to someone that you love.
You shouldn't have gone through this, ever.
Questions? They provided a lot of good information on a good sound on-scene response, along with the reasoning behind how important it is. Even, you saw the one victim talked about he used to get a look. And, I'm sitting here and I'm thinking, man, I can ask some trauma-informed questions to follow up. What was going on in your mind when he had that look? And once that's volunteered, and what caused you to think that, right? And that's where they go back and they're going to describe all these things that they had done in the past when they had that look and things. There's all kinds of information available if we recognize what to look for and what to listen for, and use that as a jumping off point to start to peel back layers. Before we go to break, anything to add, John?
No, I hadn't seen that video before. That's fantastic. Some great comments from everybody in there. The comments about stalking, comments about things that aren't crimes that are still evidence of behavior, all sorts of great stuff in there. And then the on-scene clips talking to the victim, reassuring them, so building that rapport and getting some of that history has this happened before, which is going to help me move this from, oh, this is just a couple that got into an argument that went too far, to, no, this is power and control. This is domestic violence.
Absolutely. All right. Well, it's 10:30. I'm going to give you all a 15-minute break. Please be back promptly at 10:45 and we will continue. Thank you, and see you in a little while. Going to start back up in about a minute. Okay, now we're going to talk about the domestic violence supplemental report, and this is a evidence-based report that really assists law enforcement in collecting what they need to in their investigations for first responders at the scene of these incidents. They're used across the country. We used them in Montgomery County when I was on the department, and they really do enhance the ability to get the evidence that the prosecutor needs in order to effectively take the case forward and win the case. This is the form that we sent to you all, and I think you'll either use this form or a reasonable facsimile of this form. You know, we can talk about how we can make improvements to it and so forth, but this is basically what is used by agencies across the country who are really having a lot of success in making cases where the victim chooses not to participate. So the first sheet, the first sheet on the form, basic information, the report number, the officer, reporting officer's name, the report date, defendant's name, and then you have numerous yes or no boxes that are asking things like if the defendant's a juvenile, are they on the scene? And anything, these yes or no questions, when these are checked, that's where those are things that in the narrative that we can go ahead and explain. If they left the scene, did we put a lookout for them or things like that? Were they arrested for a misdemeanor or a felony? And you circle one of those. Did we provide Miranda warnings? Was there alcohol usage? And if so, if we're checking yes, then they're having us look and say, what was their speech like? Was it slurred, incoherence? Were they shouting? Was there an odor of alcohol? What did their eyes look like? Face? All articulable facts and circumstances that they're prompting us to ask. Were they interviewed? Did we request a protection order? Was it obtained? Was it served? Was a warrant obtained? Were there visible injuries to the defendant? Yes or no? Were they complaining of injuries? And then a description of those injuries. So it's really going to asking, a lot of the things and in-depth things that we should be capturing when we're doing our interview. And the good thing about it, because they're right there, we're not going to forget about it. It's kind of like an accident report in which has all these blocks and so forth there. So if we just had a regular report, we might not remember everything to be asking and to be going for. Were weapons used? If yes, what type? And then the defendant's statement to be completed not by the defendant but by the officer, right? The next sheet is pretty much pertains to the victim. Once again, we're entering the case report number. We have yes and no boxes that ask whether that victim is dead. Were they interviewed? Were they taken to the hospital for injuries? Alcohol usage, and then and if yes, what was their level of intoxication? And, when it comes to their level of intoxication, or even the defendants, when we do DWI stops, we articulate individuals' levels of intoxication all the time. We talk about the slurred speech, and we talk about their ability to walk. We talk about tests that we give them and so forth. We can use the same criteria to make those judgments here. Did we provide them with the domestic violence brochure? Both on the victim and the suspect sheet, there's a body chart for us to mark injuries, right? And to mark an X where the victim indicates an injury, and if we can also see the injury where that X is marked, we're circling that X. That's important too, because the next day that victim, that injury might have ripened, and we're going to take a picture of that, and that corroborates what we were told originally. New address for located victim. That's where they may not be staying. They may not be safe for them to stay where they are now, so they may have another address. The relationship of the suspect to the victim, how many children in the household, their dates of birth, were they present during the incident? And when asked were they present, remember, I think we touched on it yesterday, but the child does not have to be in the room to be present. If they're in that house and they can hear what's going on, they're present, and so because they're going to be able to testify to what they heard. They're going to be able to articulate to us what they heard. The victim's description of injuries, the victim's statement, and medical release is on that second sheet. On the third sheet, these questions pertain to, at the top, they pertain to strangulation and those things that are consistent with strangulation. There's checkoff boxes that ask about breathing changes and voice changes, swallowing changes, behavioral changes, what was going on, what their face looked like, eyes and eyelids, their mouth, their neck, under the chin, behind the ears. Where did they complain of being dizzy or having headaches? Did they say they fainted? Was there involuntary urination or defecation? All of those things we're checking off, and of course, if they're checked off, they should be explained in the narrative of the report. There's other boxes that go to the method and manner of the way that this event occurred, this strangulation or suffocation. One-handed, two-handed, forearms, knees, foot. Was a ligature used, a string. It could be a phone type cord. It could be it could be the pant leg of a pair of jeans. How long were they strangled? From a 1 to 10, what was the grip that the suspect had? Is the suspect right or left-handed? What did the suspect say during the strangulation? That goes to intent. What did the victim think was going to happen when this was going on? And then other physical evidence and the list of evidence collected. The last sheet is going to have well, one of the things that's checked up on there is photographs. Photographs, just describing the injuries is one thing. Having photographs really is amazing. Having photographs, you can't describe in 1,000 words what the photographs can show. Say that, the victim was hit by a bedpost, and then we show the photograph of it. Boy, it really illustrates what that was. The victim, the suspect slapped the victim on the back with their open hand. You got that handprint, that's huge. The victim had a bump on her face. That illustrates a lot more than if that was just noted in the narrative. Having that picture to corroborate it and go with it really takes the fact finder there. So, and as Judge Bailey says, bring me the pictures. I see the marks. But above that, I see fear, frustration, despair, shame in her eyes. If she lies for him out of fear and self-protection, I will let her do it, but then find him guilty, right? So it corroborates what we're seeing. It corroborates what in context of everything is reported that went on that evening. On that last sheet, we have the witness information, any witnesses, and then we have a mandatory section that asks about predominant aggressor determination. It stipulates pretty much that you need to go down the steps to determine whom the predominant aggressor was. Were there any excited utterances? If so, they should be in the narrative. Were there any protection orders in place at the time of the incident? Yes or no? The details surrounding that. Did we do a criminal history check? Previous assaults, reported or not, we want them described. If the incident involved a child, disabled person, elderly person, we want that described. All of this is bringing things into context that we keep going back to. Was Child Protective Services notified? Were any pets abused? What was the condition of the scene? Were warrants or protection orders applied for? Were they denied? Who was the presiding magistrate? Any additional notes, extenuating circumstances, and such as justification for no arrest? It may be that the suspect fled the scene, but we want to know that. But it should prompt you to be able to realize you should be able to effectively articulate why you didn't make an arrest if arrest wasn't made. There might not have been the requisite probable cause. So all of these things, they help us to make certain that we are, as much as possible, crossing the T's and dotting the I's. Any comments on the supplemental, John?
Yeah, I really like that supplemental. I like that last question because it just makes you rethink what you saw and make sure that you can. And you don't want to just put insufficient evidence. You just want to articulate specifically. It's sort of like we talked about yesterday. Victim was upset, the furtive gesture. Just tell us why and what you saw and why that didn't amount to, in your opinion, probable cause. I also just like when you're talking about getting those photographs, that is, again, going back to what Dave said earlier about doing this case like it's a homicide. Homicide, there's photographs. Get those photographs. That's going to be powerful evidence. Not every time in these scenes is there going to be that visible evidence. And so when I'm thinking about, Dave, and I know you train on strangulation all the time, when I'm thinking about the strangulation case and all those other indicators of that strangulation occurred when you might not see the marks on the neck, that's going to be powerful. That's going to help me prove that charge, particularly depending on how my statute is written. If I have to demonstrate impairment or impeding blood flow or airflow, those symptoms are going to help me do that. And so we don't always have that visible evidence. Those other questions are going to really help me prove that in court.
Yeah, and the visible evidence, I just call icing on the cake.
Yeah.
It's another factor. No one of the factors standing alone is going to get us there. It's kind of like on a DWI, that's why we do the roadside test. That's why we articulate all of those different factors that together make us be able to articulate this individual was drunk. And we can effectively make the case whether the individual does the breathalyzer or not, because we were able to talk about the individual stumbling when they got out of the car, the strong odor of alcohol, the car swerving back and forward. Any one of those alone is not going to get us there, but all of those together is what gets us there. And so the pictures are a great thing to have if they're available. They might not be available. Then, and on scene, only 35% of the time are we going to see visible injuries in a strangulation case. So that's going to be the exception. But if they're there, we definitely want to catch them. Our follow-up investigation ideally are done by a detective or an investigator. These investigations should be geared to the requirements of the prosecutor's office. Information verification at a minimum, and confirming all steps of the investigation were completed, the on-scene investigation. They might include obtaining medical records, the 911 tape exchange, conducting a re-interview, furthering victim contact information. The victim, once again, between the time of the incident and when we do the follow-up, those things may have changed. So, or we might want to get alternative contact information, a third party that we can get a hold of the victim through if the victim needs to be in a place where they can't be directly contacted due to safety. Securing the premise history and any other domestic violence history, obtaining follow-up photos if applicable. This sound investigation with these crimes, we have to realize, first of all, as we talked about yesterday and today, they're a course of conduct type of crimes. They're not incident-based. And we're really trained to do an incident-based investigation time and time again, but understanding that these are course of conduct makes us look at the context so that we can really look at things and see them for what they are. Usually there's going to be multiple concurrent crimes. The question is, are we looking for them and listening for them? We have to take into account the traumatic impact. Understand that there's going to be minimization often by the victim or the perpetrator. How many times do we say, ma'am, sir, do you need an ambulance? And they're like, no, while they're bleeding out and all kinds of stuff like that, right? Minimization. We know these are underreported, and we know the serial nature of these perpetrators. And you know what? Anybody who's been fighting crime for more than a half a second realizes that people involved in criminal activity are serial in nature when it comes to their involvement in serial activity. It's just not restricted to intimate partner violence crimes. I mean, how many people have you locked up that it wasn't intimate partner violence, and after you locked them up that one time, they had a come to Jesus moment and never committed crime again? Time and time again, they're frequent flyers. This category of crime is no different, right? So it's not surprising that their activity is serial in nature. We know with these types of crimes that the victims we deal with aren't going to be perfect victims. That it's more the rule that there's going to be a delay in reporting the crime. Trauma is going to be involved due to the nature of the relationship with the suspect. There's going to be ongoing threats due to the nature of intimate partner violence relationships. That victim's going to feel powerless to stop the violence. The suspect knows them better than or as well than anybody else, and they're going to utilize those things that are to that suspect's advantage. So they're going to take advantage of that victim's vulnerabilities. The victim may distrust the police because of their experience with law enforcement in the past or what they've seen. And some of them literally, many of them love their suspect. They love that perpetrator, and they want the violence to stop. They don't necessarily want that individual to get in trouble. We have to be cognizant of that. We have to be cognizant of the nature of this perpetrator, of this criminal. They plan their crimes just like other criminals. They do what they do in front of people that they don't think will hold them accountable or are interested in holding them accountable. They are manipulatives, they're strategic, they're calculating. They engage in grooming behavior that we've talked about. They test their victims, they test us. And they're often, it's serial in nature again, serial offenders. And the violence escalates over time. That's why we talk about these crimes, this type of behavior, graduating from misdemeanor behavior to felony behavior, and ultimately homicide in many cases. We've got to be cognizant of how dangerous this category of criminal is, how dangerous they are, not only to the victim, but also to us.
Has he shot anybody? He fired a shot. I don't know if he shot or not. And he just choked me. And I'm afraid for my son and my baby. Please hurry, please. Oh my God! Where are you at?
Victims of domestic violence, they're like a prisoner of war.
Officers have to understand that either you're our knight in shining armor or you're our worst nightmare.
The police are on their way, okay?
The question is, when do we change the culture and all stand up and say that violence against women is something we're not going to tolerate in policing? This is not easy.
Stay there, stay there. I'm coming.
What's easy is for me to sit here and to tell officers exactly what they need to do. I know how hard these cases are.
I need cuffs. Post Falls, we have one male detained. I don't know, she's right over there, contact her.
Okay, she's bleeding from the face.
Most crime that law enforcement responds to are incident-based. It's a single occurrence, whereas when we look at domestic violence, it's a course of conduct. It's multiple incidents over often extended periods of time.
When a victim calls the police, it may have been the 6th or 7th incident.
Which is really important because I think that when law enforcement come and they see that there's been a physical altercation, there's usually been this whole history of things that have happened before then that don't always rise to criminal behavior. But tell the full story of how powerless she is in the context of the relationship.
An abuser found my mother, and it was my stepfather, and it was emotional, it was psychological, it was really physical, near-death experiences over and over again over a 10-year period. The officer that came to my house stood on our front porch, and I heard him tell my mother, if we come out here one more time, you're going to jail. And my mother just shook. I mean, and it's one thing for a parent to hold a trembling child. It's a whole other thing for a child to hold a trembling parent. And I never forgot it.
The victim of abuse, who may have used a level of violence in defending herself, who now gets arrested, now, what do they think of the justice system as far as being a system of help and a system that they can turn to? And what'll happen is they simply won't.
If you had a cheat sheet in your pocket, here's what you want to do. You want to identify the offender. You want to identify the victim. You want to locate the offender. You want to document your evidence, and you want to find your probable cause.
Do not move, all right?
Yeah, it's okay for her to hit me in the face, right?
We'll get this all figured out in just a minute, all right?
Fuck that.
I like to call this bully determination.
Hold on.
Yeah, I was going to say, Dave, did we mean to replay this one?
No, it was, I thought we had the right one.
Face.
Most
determination. Determine in
I think maybe we embedded the wrong video.
Yeah, that's what happened. Let's see. I know where it is. Where is it?
This is training overcoming trauma.
Yes, it is.
Someone being able to do this on the fly is pretty good.
Women is something we're not going to.
What's the problem? This is the police department. What's the problem?
The very moment the radio dispatch comes in and the dispatcher says, domestic violence call, something happens to you as an officer.
Who has a gun to your head?
You start to think about your own survival.
Every scene is different.
I'll be making a quick stop at Clay F.
For the police officer who is approaching that front door, it's the unknown.
The offender comes in all kinds of flavors. From walking out to sticking their hand out and shaking hands with you like they're a real estate agent when you pull on the scene, to someone who's standing on the front porch waiting for you to get there so they can tell you you can't come in my house, threatening you with a lawsuit and saying they're going to have your badge, or somebody that's going to meet you with a gun or a knife.
You mind if I just pat down your pockets real quick? You don't have anything in here? No. Okay. Nothing in here? No, this is my smoke. Okay.
We have buried U.S. police officers in this country for over 300 years, killed answering calls, where there's a violent man there often abusing their family. This should be the very best thing we do, because all the things that an offender will do to their family is what they'll do to a responding police officer.
There's a female party that's on the line, and I can hear the men in the background.
It's very important to have as much information as possible before rolling up to the scene of that domestic violence. Information like, have we been here before? Have there been arrests here before? If there's been arrests, who are the occupants? Are the occupants wanted? Is there any warrants for those individuals? Is there any mental health information that our officers need to know?
It's amazing officers don't get hurt more often than they do. You know, people are emotional, the police are in their house. Almost always there's substance abuse issues there, some type of intoxication, or somebody's drunk, high. You know, really teamwork is probably the biggest key to safety when we're responding to these kind of calls. The more people we have, the safer we're going to be.
That's a struggle that you have in small communities. You may not have backup for anywhere from 10 to 30 minutes. You run into issues of radio contact.
Talking from a landline.
You get out of cell phone contact. Some roads dead end. Yeah, I'm not gonna try this. If I go in with an attitude and I go in being abrasive and rash and pushy when I first get there, well, then that's probably not going to turn out real well for me when the next officer's not coming for 15 minutes.
It's not unusual to see about a third of your calls are repeat calls. And if you get a lot of repeat calls, that often means someone's using more violence in a shorter period of time.
I need backup to expedite. I've got a female being dragged. My car just got hit.
One more time.
Post files 1138. We're northbound William. A female is being dragged.
I have actually talked to officers who told me, I got familiar, I knew the guy, I'd been there 3 or 4 times. I decided to pull in the driveway. I thought, I won't hit the end of the street. I'll wave my back off. I don't need them. I think I know him. And I ended up having to shoot this man. I've had officers tell me that on domestic violence calls. Because you think you know someone, and again, what you don't know is the dynamic of that family at that moment when that victim called the police.
Hey, what's your dad doing? He's killing my mom. With what, honey? With what? A gun.
When you talk about victim safety, you've got to talk about your own safety as well. You can't separate the two. Which means you've got to ask the victim questions you might not have asked in the past, like, has he ever threatened you or your children with a gun? Do you think he might try to kill you? Has he ever assaulted you while you were pregnant? Has he ever strangled you? Has he ever forced you to do something of a sexual nature against your will you didn't want to do? I mean, these are questions that may not have relevance to the very moment that you were there about the assault, but the context is critical.
We should always assume that there might be some type of weapon. Add alcohol and drugs, and then you have a volatile mix.
I'm sorry, oh my gosh! Where are you at?
If this individual seems to be dangerous, we need to get those guns out of their hands.
If you don't pick up on some of those things, and you don't make an arrest, or you don't at least provide services for that victim, the next time your fellow officer goes back, the call may be much more serious. Your fellow officer may be under greater threat of either violence or homicide.
All right, here we go. That situation is still ongoing. Has a DVPO come down?
That's the one we discussed last night about where she's staying at. So when y'all serve him, that's got child custody in it as well.
If you're offering any kind of service, a protection to a victim of domestic violence, you're now a problem for the offender.
Be safe. Just need to pay attention to what goes on in your surroundings and tactically aware.
If we just assume that these men kill out of a sense of power and control over women, we miss the complexity, because often they kill when their power is ebbing, and often they kill when they feel they're not in control.
Usually these folks are really emotional. A lot of times this is the first notice that things are serious. So they'll do what they can do to try to avoid service.
My mileage is 675, and I have other units here with me serving.
And this is what times leads to officer injuries, officer deaths, because when they start losing control, we start gaining control. And we have to gain control in policing because we're responsible for your safety.
Folks who violate protection orders are some of the scariest people that I think that I have to deal with.
All rise, please.
If he's out to get you, he's out to get you, and he doesn't care about that order of protection. That's just a piece of paper to him, until you're cut up or beat up, and then somebody shows up to help you.
The threat before this threat is what's worrying me, though.
What was that threat?
That if I ever was to get another protection order against him, that he was going to make it worth it.
If you've got protection order violation, if you've got a bail condition violation, if you've got someone who's thumbing their nose at a sanction that a court's levied on them because of domestic violence, that's a high indicator before you even arrive on the scene.
He told me that he would kill me and hide the body and act surprised when the police came. He had told me before that the police were nobody special, and he didn't have any problem standing up to them.
Domestic violence offenders coerce and threaten, intimidate victims. Why do we think that offender wouldn't use those same tactics on a responding officer? Let me isolate the officer. Let me intimidate the officer. Let me coerce the officer. Let me threaten the officer. Let me assault the officer. Let me use my kids against the officer. Let me use my wife against the officer. Please don't take him to jail. Don't do this. We'll lose our paycheck. Let me use everything that I use to keep my family under control, to controlling that officer's response as well. If it works on one, try it on another.
Is someone there trying to call for the police or an ambulance?
No, that was an accident.
No, it wasn't an accident. Get over here.
It was, sir.
It wasn't an accident.
Sir,
So what exactly is the problem there?
I have no idea.
Get over here.
The bottom line is you've got to take each and every domestic violence call serious. You can't lower your guard. You can't minimize. If you minimize, you'll get hurt or the victim will get hurt. And this is something that no officer wants.
I'll be making a quick stop at Cliff.
It's clear that these can be very dangerous situations, and that's one reason why we use tools like the danger assessment, various forms of lethality assessment to try to gauge what we have going on to operate in as safe a manner as possible. And there are numerous assessments out there, and some, they all have pluses and minuses. You have to use the assessment that works better for you and the community you're in, depending on the resources that you have. For instance, the LAP that was mentioned earlier. In order to use the LAP, you have to have the participation of a local service provider, because there needs to be 24/7 somebody ready to receive calls 24/7. So when there's a certain score on that LAP, or when the officer perhaps or deputy feels that individual is in high enough danger, they need to connect them by phone directly to the local service provider, because we know that getting somebody to services across the country, nationwide, over the last few years, the fatality reviews tells us that's one of the things that really saves lives. But this is the original danger assessment developed by Dr. Jackie Campbell out of Johns Hopkins University through her extensive research on the topic and her work with women who had been battered. And with Neil Websdale, who you saw in the video, informs us that there's really no precise way to pinpoint who is going to die and who isn't, due to the multiple variable factors that influence whether one lives or dies. But what we get from victims is directly related to the touch and sensitivity we put in. People are going to tell us what we want to know in accordance with the relationship we've developed with them. Thus, risk assessment isn't as much about asking questions as creating a climate really to make that individual comfortable to share information with us, which means we have to invest the time and the effort. We know that risk and lethality goes up exponentially in situations where there's co-occurring domestic violence and sexual assault. Research overwhelmingly shows that intimate partner sexual abuse co-occurring with domestic violence is the leading indicator of femicide. So if you have sexual assault and domestic violence going on co-occurring, leading indicator of femicide. A physically abused woman is also who is also experiencing forced sex is 7 times more likely than abused women who aren't being sexually abused as well as physically abused. They're 7 times more likely to be killed. So assessing the risk that the abuser possesses, obviously it's multi-faceted. As Dr. Websdale just informed us, leading results in the abuser being not only outraged, but they feel as though they're losing their link to their world, their own world of feelings, and losing control over their victim. And impending divorce or separation often prompts renewed or first time sexual abuse in that relationship. 20% of the women in these relationships who are raped, in other words, 20% of the time, sexual assault occurs after separation. So we talk about half the time that victim is being sexually abused. Well, 20% of the time, this starts after there's been an attempt to separate, and it's usually in order to, in a desperate attempt to maintain that power and control. We know it's commonplace for these abusers to perpetuate, who perpetuate murder of their victim, to commit suicide. 1/3 of the time, almost 33% of the times, these individuals are committing suicide after they commit the murder. The psychological damage or trauma resulting from sexual violence, coupled with the physical violence, increases the likelihood of suicide for victims as well. In one study, 22% of sexually assaulted, battered women reported suicide. So when we see that combination on there, when we're doing our lethality assessment, we know that victim is also in danger of harming themselves. Per the study by the Bureau of Justice Statistics, on average each day in the U.S., still more than 3 women a day are murdered by their current or former intimate partner. Forced sex just increases the risk of homicide over and above prior domestic violence, the use of a weapon, and repeated physical violence. In other words, the individual who physically abuses their partner but also rapes them is particularly dangerous. All right, so, and victims of white rape are at greater risk of being murdered by their husbands or of murdering the individual who's abusing them than battered women who are not sexually violated in the relationship. Any situation that this next part really goes to the danger to everybody involved, because any situation that heightens lethality for the mother heightens the risk of lethality for their children and for third parties. That means for interveners, for us as law enforcement, for relatives, bystanders, court personnel. We also know that most battered women who have killed their intimate partner were also being sexually assaulted. And I keep mentioning the sexual assault because of its relationship to this thing getting really lethal. And so that's why we've got to get the whole context. That's why we have to ask these questions. You heard Mark Wynn, retired lieutenant from Nashville, in the video talk about, asking the question, have you ever been made to do something of a sexual nature that you weren't comfortable with? We have to be able to ask the difficult questions. And not only do we need to know for the safety of everybody involved, but the court needs to know. The court is in a situation, in a position where many times they're going to be deciding whether, for instance, a protection order can be issued. And this just might be all that's necessary in order to issue that protection order. We've talked about strangulation, we've touched on it. And we know that that's one of the factors on there that causes us to realize that this situation is becoming lethal. We know that half of physically abused victims are also sexually abused. 1/4 of physically abused victims are strangled, and 1/4 of all sexual assaults cases include strangulation. Once again, the co-occurring nature. So that means we have to put in the time and the effort to really find out what's going on. We know that female intimates are more likely to be murdered by a firearm than all other means combined. In the US, 32% of the female population were high income from high income countries. Even though 32% of the female population in the world come from high income countries, yet account for 85% of all female homicide by murder. In other words, that these individuals, even though the high income country like the US only make up 32% of the population of females in the world, but because of our proliferation of guns in this country, 84% of all females murdered worldwide are from the US. And so it's important that we know these things. It's important to know, for instance, whether or not this suspect, this perpetrator, has avoided being arrested for domestic violence. It's a factor that has been found consistent with individuals who end up murdering their significant other. It's important to know what the factors that are there when it comes to officers killed in the line of duty responding to domestic violence calls. These factors have been consistent for 25 years running. You know, most officers killed in these incidents aren't alone. They've had time on. Most were killed while approaching the residence. 41% of the arriving officers had indications of lethal danger, and they went forward anyway. Half were exiting their vehicle when they were killed. Most of the perpetrators had homicidal intent. In fact, in other words, new officers were coming and were planning to go out, whether it was, you know, they were trying to get suicide by a cop or what have you. The second most killed were killed on initial contact with the suspect. We know that the first minute that there's the interaction between the officer and the suspect, the first minute is the most deadly. Sometimes it's because of tombstone courage, impatience, you know, not waiting for backup. In most of these cases, alcohol was present. In many of these cases, there was a failure to restrict the movement of the perpetrator once they perhaps got inside the home. 57% of perpetrators were unstable or suicidal. Most of them, that I'm sure you're not surprised, were frequent flyers. And some of the officers were even killed by handcuffing, you know, while handcuffing, you know, letting their guard down. So, you know, and these things, this study was done by the Federal Law Enforcement Training Center over a 10-year period. And we're finding consistencies again and again. We know when it comes to the firearms and the use of a firearm, that 4% of all domestic violence victims report being threatened by a firearm in their relationship, with 1% sustaining injury as a result. Compared to homes without guns, the presence of a firearm in the home is associated with a threefold increase in the risk for homicide. When you add the element of domestic violence and a firearm being in the home, it increases to an 8-fold risk of homicide. Female intimates are more likely to be murdered by a firearm than all other means combined, according to the Center for Disease Control. 77% of these homicides are by firearm. We also know that laws to restrict firearm possession by individuals who have a protection order against them is responsible. It correlates with an 11% reduction in rates of intimate partner violence. So we have to be aware of that, of the relationship between firearms, the presence of firearms, and individuals who use them to kill their significant other. thus, it's important for us to know the law, the federal law. You know, and I understand that most individuals, including myself, when they're in law enforcement, we can't enforce federal law. We're not federal agents. But we can, if that individual is in violation of federal law, we can take their firearm and turn it over to the feds, because in their possession, that firearm is contraband, and they can't argue that they can keep their contraband. So it's important that we know the federal law, that we know that if they've been arrested, if they've been convicted of a domestic violence, a misdemeanor type domestic violence case, that they cannot possess a firearm. If they've been convicted of anything where they've had a year or more, they can't possess a firearm. If they're a fugitive from justice, a CD, controlled dangerous substance user, if they have mental health issues, if they're an illegal alien, if they got a dishonorable discharge from the military, they cannot legally possess a firearm in this country. And these individuals, you know, as I mentioned, they're dangerous not only to that significant other, they're dangerous to us. We talk about these individuals and the context and their background, and how many of them who strangle kill their significant other. We know they kill us also, and we know by the time that they're also, when we look at it, we've been looking at it a lot more over the last few years. Look at how many of these individuals who commit these mass murders, whether it's the case up in Pittsburgh at the synagogue or the case down in Las Vegas. Look at how many of them have a history of intimate partner violence. Again and again and again, we are seeing that. We know that the federal law says if an individual citizen, if they've renounced their citizenship, can't possess a firearm. If they if they are subject to a court order, they can't, that prohibits them from possessing the firearm, they can't have it. Qualifying misdemeanor conviction of a domestic violence crime or under indictment. All of these things means that we can take those firearms out of their hands. And we can, once again, we might not be able to lock them up for it, but we can take their firearm and turn it over to the FBI or whoever is the closest local federal agency. And why? Why is this important? For the safety of everybody involved. You know, these cases take up a large percentage of our calls for service, and they are absolutely, the research tells us how dangerous they can be to us. Even, you know, when we look at call outs, you know, I was a SWAT officer, I was a hostage negotiator, and this held true for us. You know, we had an average of 3 to 4 call outs a month, and the vast majority of them were domestic violence related, where, you know, the vast majority of them, these individuals, you know, they were trying to kill somebody else, they were going to commit suicide, you know, all of these, but it was all of it. The root cause was some domestic violence related type of an incident. And, you know, do you know the landscape? What percentage of officers' violent line of duty deaths are by way of firearms? Do you know the answers? If you do, put it in the chat. Do you know what percentage of officer violent line of duty deaths are by way of firearm? Okay, it's 90%. State and private ownership of guns was associated with less officers killed in the line of duty. True or false? What do you think? Private ownership of guns associated with less officer killed in the line of duty. You think that's true? Do you think it's false? Happens to be false. State private ownership of guns was associated with a lower violent crime rate. True or false? Happens to be false. States with the highest gun ownership had 3 times the officers killed in the line of duty. True or false? States with the highest legal gun ownership. That's true. Know the facts. Know how dangerous these weapons can be in the wrong hands. All right. We know that domestic violence calls are one of the deadliest calls that law enforcement goes on. According to the 2020 National Law Enforcement Officers Fatalities Report, out of the 264 officers killed in the line of duty in 2020, the second highest cause of death was firearm-related fatalities, where 48 officers were killed in the line of duty, 7 out of those 48 being responding to domestic violence calls. Numerous more officers have been severely wounded on domestic disturbance calls over the recent years. In 2017 study, 33 or 40 officers killed intentionally in intentional homicides were murdered by men with a history of domestic violence. In another study, looking at looking at officers killed between 1993 and 2013, over a 10-year period, half were killed by a criminal suspect with a Public Records Act history of strangulation, assault against women. And between 2017 and 2020, 182 officers were killed by firearms. 46 of these officers were killed by intimate partner violence perpetrators, offenders. So the correlation is there. It's stunning, and it begs that we do a good, thorough investigation each and every time we get the opportunity. Each and every time we get this individual in our crosshairs. And it starts with, when we get there and there's injuries to both, or there's only injury to one. We can't assume that the violence was justified. We have to do that self-defense, start out with a self-defense assessment, because if it's in self-defense, there's an absolution of guilt or culpability. If it's justified, if they can articulate that imminent fear and reasonable grounds, and the amount of force used in order to defend oneself isn't unreasonable. And the question is not, do I believe that I would have used force in that situation? The question is, under the circumstances articulated, did the individual believe that they or the person of another were in immediate danger of death or serious bodily harm? If the answer is yes, then the next question is, was the amount of force that they utilized in the situation within reason? Right?
Dave.
Yep.
Before you play this, we got a chat, and I just wanted to bring it to your attention.
Okay.
So we put out TPOs, temporary protective orders. Individuals clearly violate them. Enforcement of these is difficult. The courts just put out another order for service, in many cases, stating to subject, if they can be found again, to now come to court to address said violation, as opposed to cutting warrants for aggravated stalking or violation of a court order. We do not get to take subjects to jail, often due to COVID protocols. Better means and ways of enforcing these orders would be nice. As stated in this training, people do not care about that piece of paper.
Yeah, well, I mean, that's a fallacy. I mean, that's a hole in the system when it comes to the seamless response. If they're not enforcing those orders, and perpetrators quickly find ways to take advantage of that lack of follow through by the system in my experience. And that's, you know, I know in certain places in the country when they've had these type of problems, they've done court watch and things like that in order to illustrate for the public, because you're going to have, there needs to be a public outcry and show the danger not only to the victim but to the public in general, as I've articulated here. These individuals aren't only hurting and killing the target, they're hurting and killing others. You know, whether it's at Mandalay Bay down in Las Vegas or any of these mass shootings that these individuals are tied to. But it's a reality that you have to deal with when you're doing your job as law enforcement and the prosecutors doing their job, and the judiciary is not following through. John, what do you have to say on that?
Yeah, and you know, honestly, I think we often, I think I've taken them not as seriously as they should be. When you tie that to the mass shootings and the other dangers to officers, I think that's a powerful argument to make in court, to just say, hey, we can't take this for granted, including the cases where the victim has invited the offender over after a protective order. Because look, it's a domestic violence relationship. There's power and control going on. I have no idea if that's some voluntary act on the part of the victim or manipulation by the offender, and I don't want to find out. I just want to hold his feet to the fire. He was ordered to have no contact, and we should take every one of those seriously, no matter what the circumstances were. And we can do a better job. I think I can do a better job arguing it, particularly when you've gone the extra mile to bring that case to my attention.
Well, and this whole thing, you know, part of the dynamics of the relationship, it shouldn't be surprising that perhaps she invited him over, made much due to pressure he's put on her, or even if that's not the case. The order does not stipulate anything against behavior she is not allowed to engage in. It stipulates what he is not allowed to engage in. And she can't overrule the judge's order. So the bottom line is accountability. Let her blame it on me as the officer for locking him up. I have no problem with that. It's just like let her blame, she's sitting there, no, I don't want him arrested. You know what? It's not her law, it's the state's law. And so that has to be put in context well. You know, sometimes people say, yeah, I've heard it said that you know, they say some victims are bilingual. They say don't lock them up when they really want them locked up, right? But they can't say that in front of him,
right?
Because they've got to live this. So, you know, you got to really take it. The more you know the nature of this type of animal, the better you're able at not going with the smoke and mirrors that they're depending on so that they can stay out of cuffs.
Yeah, I've made that argument or put it on the record in court that the victim did not want to proceed today. Just as that, like, okay, you know, she did the bit. She told us she didn't want to go forward, and now it's official on the record in front of the court.
Definitely. All right, let's watch this video. And when you're watching this video, think about what you would do given this situation. Think about the suspect's name is Willie. Think about what you would do if you're confronted by Willie in this manner.
Charlie 25, respond to the Chico Club 7366 El Cajon Boulevard to a male causing a disturbance outside. Be advised the suspect is described as a white male, 6'3", 260, wearing a blue sleeveless jean shirt, white t-shirt, khaki pants, named Willie. Reporting party states that Willie has been assaulted toward police in the past.
How you doing?
Show me what to do.
You Willie?
Show me what to do. Tell me. Yeah.
How much you had to drink tonight?
Why don't you shut up?
Put the bottle down. Put the bottle down.
No. No. No.
Okay, so at the end, Willie, he's saying no, no, no. He's at the end, he takes a step I don't know if you could see it clearly. He takes a step, but he's saying no, and it looks like he's raising that bottle up. What's going to happen to Willie, do you think, if you're confronting Willie? I mean, is Willie going to get tased? Is Willie going to, what's going to happen to him? Or do you think you have what you need to utilize force? I mean, I'm thinking, I'm going to articulate exactly what's going to happen to Willie. I'm going to articulate he was, when I arrived on the scene, he was in a seated position and he went to a standing position. I'm gonna articulate that I was informed by dispatch. If I worked that beat, I probably already know who Willie is. I probably already know he's a police fighter. But that is part of the information given to me by dispatch. I'm going to articulate that he's 6'3", 260. He's a lot bigger than I am. All of that is going to go into me laying the facts on the line so it can be seen why I decide to use whatever level of force I decide to use against Willie. I give him repeated verbal commands. Not only is he not, I can see he's not following those commands, he is articulating no, no, no. His voice is going up as he is saying that. He goes from that seated position to a standing position. The bottle, when he's standing up, the bottle goes from his left hand to his right hand. In my training experience, most people are right-handed. All of that I am going to put in to talk about why I'm not saying I'm going to use force against Willie because I'm in fear, right? No, I'm laying the facts out on the line. Now, and I go through all of that because we already have experience, training and experience on how to assess whether or not self-defense was justified. We can ask questions to the victim or to who we think might be the victim, or to the other end, or to the suspect, that go to whether or not they were in fear, that go to why they thought something might happen. If we're interviewing a victim, we want to give them the same respect that we would want when we use force. So we can ask them, are you able to describe what you thought was going to happen, in the incident, in this confrontation that you had with your significant other? Can you tell me more about that? Once they start saying, well, I thought he was going to hit me. Can you tell me more about that? What was going on in your mind when you picked up the knife? Say the victim did use a weapon against the suspect. A weapon a lot of times is an equalizer. It sure is an equalizer for us as law enforcement, right? We use weapons. We're trained to use weapons, and we can articulate justification. The victim may have used a weapon in this case. Can they justify why they picked up the weapon? They might talk about something to the effect of, when he did this in the past, I got my butt kicked, or anything like that. If they can't articulate it, they can't articulate it. What made you think that, right? Can you describe what you were thinking and feeling when he came near you, right? And they're open-ended, trauma-informed questions. What caused you to think that? And so we're asking all these questions to put things into context, to find out what was going on. None of them are leading questions. And we should always be making these determinations before we jump to making that predominant aggressor determination, because if they use self-defense, they're going to be justified in the amount of force, in the amount of violence that they utilized in the situation at hand.
Dave, we got another quick comment about the self-defense video. The individual said, I would talk a little more before I responded with whatever force you felt was necessary in that situation.
Yeah, well, and that's fine. I mean, everybody is going to have to justify what they do or don't do. There's some individuals who might act sooner when it comes to hands-on type of stuff, and some who might retreat more and everything. It's all going to be it's all going to be based on what you perceive at the time. You know, we can't see if there's anybody else close to Willie that he could hurt. It didn't look like it, so that might be absolutely legitimate. We want to do everything in as safe a manner as possible. And, you know, it might be a thing, if we're out there, it might be a thing where we can go a ways further before we have to go hands-on. So yeah, I can see that being legitimate. You know, in these cases, in these relationships, do women use violence? Well, you know, there's no question that there are women throughout history have utilized violence in various ways. Put it into context, though. Let's go with the research. Let's go with what we know, that most battering in heterosexual relationships is perpetuated by men, and most male victims of battering are being battered by their same-sex partners, by other male partners. It's not to say it doesn't happen the other way. It's to say that each and every time we go in and do an investigation, even though we know this is what happens most of the time, it might not be what happened this time. So let the facts take you to your conclusion. We know there are mutually abusive relationships. And in this context, we're talking about a relationship in which both partners exhibit violent, abusive behavior in which power and control is the goal. But research tells us that that type of relationships are rare, mainly because neither individual is able to achieve their goal and they both go their own ways, although they do exist. What we really need to do is get to the core issues like power and control. The context of the violence has to be part of the discussion. And we need to really make sure that the violence isn't simplistically counted, that it has to be viewed in the context of social inequities and gender roles that violence helps to keep in place. Counting the violence shouldn't be as much of the goal as looking at the meaning and the consequences behind the violence. So the challenge really is to take all the violence seriously and not lose sight of the facts. So, you know, what is the intent of the violence? Is it to take something? Is it to keep something? Is it to control? Is it to punish? Is it in self-defense? What impact or meaning did the violence have on the parties? What do they take from it? If threatened, will they run and hide? Will they stop speaking up? Will they fight back? Did someone fear death and or fear future violence? Will somebody be more vulnerable of other forms of abuse? Comprehending battering violence, we have to put it in the context. If we comprehend it only in terms of violence, then we probably can't fully construe its implication. You know, if you have a person, a man being robbed by a stranger, and he overpowers the robber, breaking the robber's nose and making a citizen's arrest, you know, that second act, that second assault is most likely going to be looked at differently than the first assault. One's going to be considered justified, and the other is going to be considered criminal. And so, as I touched on before, we really have to look at this in these relationships as dealing with the bully and finding out who in the relationship is the bully. You know, if your kid comes home from school and talks about being bullied, then we're going to be asking some questions. We're going to be wanting to know how the situation transpired. This is my son Nick on the right, my son Jake on the left. Nick's when he was in first grade, he comes home from school and he says some kid stole his lunch money. And I'm like, what are you talking about? And he's like, this kid, he's in fourth grade, he's much bigger than I am. He took my lunch money. I said, Nick, did you tell the teacher? What'd you do? Well, yeah, I told the teacher. And they said, well, okay, and they They got my lunch money back, but then the kid was really mad at me and told me I was going to get it after school. And after school, he chased me some, he didn't catch me, and all this kind of stuff. I said, well, look, I want you to avoid this kid. I want you to stay away from him. If you have any problems with him in the future, you tell a teacher, you tell the principal, and I'll call the school and make sure. But if he approaches you, you can defend yourself. Of course, being a defensive tactics instructor, I taught him how to defend himself. So things go on. I get busy with work and so forth, and I forget to call the school. But then 3 weeks later, I get a call from the school that informing me my son's being suspended for fighting. And of course, I'm like, oh, here we go. So I go down to the school. Nick's in the office. This other kid sitting across. Both of them look like they've been crying and so forth. And I'm like, Nick, what happened? And he's like, well, I got into a fight. I mean, what do you mean you got into a fight? I said, well, you remember I told you about that kid who was stealing my lunch money? And I said, yeah. He's like, well, he continued to do it. And I said, well, did you tell the principal? Did you tell teacher? Yeah, I told him, but they said basically, boys will be boys, and he was doing it in places where nobody could see. And Dad, I was hungry today. I wanted to get lunch. They were having pizza. And I'm like, well, so what happened? Well, I was on the way to lunch, and he got where he always gets when nobody can see him. And he jumps out and he says, Thomas, give me your lunch money. And he's like, I didn't want to give him my lunch money. He said, so I go to stick my hand in my pocket, and then I pull my hand out and bam, I hit it. And I'm like, that's my boy, of course, but no, really. And so, and he explains what happened and how he knew exactly that this kid was going to push him down and beat him up like he had in the other days. And I was like, man, and this is a prime example of what happens to victims, right? When they fight back, when they defend themselves, because they know exactly what's going to happen, and they can articulate how they knew it was going to happen, they get in trouble, when we go and we talked about Willie in the scenario and the things that we're going to articulate to justify our use of force. I think most individuals would agree that all of those things are going to be justifications. What are we talking about there? We're talking about history, right? In order to justify self-defense, in order to justify use of force. And do we give victims that opportunity to talk about the history? We get there on the scene, say, ma'am, can you tell me what happened? And they say, well, 3 weeks ago. That's when we're like, take that deep breath and say, like, man, I don't care about what happened 3 weeks ago. I want to know what happened tonight. Well, what happened 3 weeks ago might matter. That history can give context to what we're investigating tonight. And we should want to know about that history, right? We certainly want the fact finder to know about it when it involves us, right? And we have to utilize force. And this goes to really being aware of the nature of the environment when we're not there. And once we can know that, once we can walk in that victim's shoes, we understand. Let's see if this is going to play. Oh, can't play. Sorry. I have to go on without that video. So let's look at this case study. In this case study, a boyfriend and a girlfriend return home after a night out on the town, and they get in a confrontation. The boyfriend confesses to his girlfriend that he had sex with another woman, and the girlfriend slaps the boyfriend. He retaliates and assaults her. Just knowing that, what are your thoughts? If you right now have to address this, you've got that little bit of information. What are your thoughts? What do you think you would do? What, if any, additional information do you think you'd want to know? Hopefully, you'd want more information. but that's pretty boilerplate, okay? So let's take this a little further and look at what happened in this situation. A deputy arrives and doesn't see any marks on either party, all right? The boyfriend does not admit to any wrongdoing during the incident. He doesn't admit to the assault that he made upon her following her slapping him. She does, though, admit to the deputy that she had slapped him. She is then arrested based on her confession. And then the following pictures were taken at the jail 10 hours after the arrest. So she's arrested, he's left at the house, and they go to the jail and these pictures are taken. And you see up at the top, this injury here. What is that indicative of? If you see that injury on somebody, what does that make you think might be at play in this assault? Anybody want to put it in the chat? Yeah, I see choking. Yep, strangulation. Absolutely. So it's most likely a thumb bruise from the thumb digging into her throat. There you see it again. Bruising on her arms. And what does that, what would you gauge, or what would be your guesses to the cause of those injuries? I think if somebody was grabbed by the arms and shook back and forth, that could happen, or dragged. Yep. Bruising to the chest, top of the arms. So these injuries are seen. She's taken to the hospital after her parents pick her up because she's complaining of the pain from her injuries. She's diagnosed with a broken rib and a broken hyoid bone. As they look further into the case, charges against her are dismissed. He is then charged with aggravated assault. And this is because in the subsequent investigation, they go back and they do a subsequent investigation. The victim strikes the suspect out of fear. She's able to effectively articulate that once they started getting into an argument over his admission to being with another woman, and he came at her in a manner that caused her to believe that he was going to assault her. And she's able to articulate that it was just like he had come at her in the past when he did assault her. So she strikes the suspect trying to, in self-defense. The suspect then begins assaulting her. He drags her across the floor of the living room, drags her out onto the deck of the townhouse they're in. The suspect kicks her and hits her. The suspect strangles the victim until his cousin pulls him off of her. And the suspect cousin, now they interview the suspect cousin, who corroborates the victim's accounts of the events. And here, the main point, all this could have been done at the scene, but it wasn't until the parents complained, until it was found out about. And so, this is where we can't just go by injuries alone, because they standing alone mean nothing. An assault, an admitted assault alone by itself means nothing. We have to put it in context. And we have to realize that the predominant aggressor is the party who possesses the most serious threat, not necessarily the one who first engaged in assaulting behavior, the one with the greatest ability and inclination to inflict physical injury. We have to get the facts. We have to ask for clarifications as necessary. As long as we've got to view it as the criminal activity that it is, or else we're going to be bumbling. We have to look for relevant information. Our decision making can then be based on the totality of circumstances. And we are trying to ascertain, once again, who's the most ongoing threat. In these cases, it's going to be common for both individuals to claim that they're the victim. And in making our probable cause determinations, the Supreme Court has stipulated that we go by the totality of circumstances. And the court ruled in the two-prong Aguilar-Spinelli test that where there's a lack of weight in one prong, credibility, the credibility of the individual, it must be balanced by more weight in the other prong, the reliability of the information. So the court also stated that, quote, and this is important, considering only some of the available information, as I stipulated before, if I ask and the person won't give me information, it's not available, but I have to at least ask. Considering only some of the available information before making a probable cause conclusion can lead to an arresting an inappropriate party and making prosecution of the case unlikely, and thus law enforcement must consider the totality of circumstances when making a probable cause arrest. We know that injuries to one party or the other in and of themselves have no meaning and should never cause any automatic decision making. How many of us have injured a suspect during an arrest and yet came out totally unscathed, right? It happens. We know it happens. It happens all the time. That's why we have to not assume. That's why we have to go by critical thinking. And the power and control wheel really does come to our assistance here, because it helps us when we look and see who is being isolated, who is isolating the other. Taking that suspect's phone is isolating them from getting the help that they may need, right? Who's engaging in emotional abuse and economic abuse and everything? Who's trying to take something? Who's trying to keep something, right? And understand that everything on the power and control wheel can be matched to criminal behavior, right? I mean, look at that. Emotional abuse, simple assault, economic abuse, theft, fraud, robbery. How many times do we find the suspect in these cases engaging in these criminal acts? When we look for it, we find it time and time and time again. We have to be aware of how that individual not only tries to intimidate the victim, but us as well. Following us from room to room as we're trying to do our investigation, if we allow them to, taking an aggressive stance, giving us looks and so forth. They do it, the more we allow them to do it, the more they do it. Isolating the victim from us, saying, she's not available, not letting us into the residence and so forth. Isolating her by, while we're responding, they know we're coming and they're getting those kids out of the house, right? And doing whatever they can to interfere with our access to the victim. They're using, as I mentioned earlier, using the mail card and saying, I can't trust her with the money. That's why I got to keep it. laundry. I had to take her keys till she would settle down, you know, that type of thing. And that really is more of using the male privilege, you know, saying things like, I don't know how you handle things in your home, but in my home, this type of thing. These individuals will use as much as they can. Making threats, you know, I'll have your badge, I'll sue you, you know, I pay your salary type of thing. This is very commonplace. You know, saying things that minimize, denies, you know, and these minimizations, some of them are admissions to being guilty of the acts that they are being looked at for. But we see them doing these things all time and time again, and they're all power and control tactics. Using those kids, you know, they are above nothing, and they will use whatever they can in order to try to not be held accountable. So, and then on top of that, we have a victim who, due to the nature of what's going on, they just want the violence to stop. And when that suspect tells them, that perpetrator tells them, well, it'll never happen again, they want to believe him. They believe that suspect, well, you made me do this because you didn't do this, that, or the other. There may be religious reasons, and when it comes to the threats made against them, they believe them because they've lived them. They know what that individual is capable of carrying out. And so investigate the power and control. Who's in fear of the other? You know, what kind of trauma responses do we have? Who's calm and controlling? Who seems to be in need of protection? What does the history about these individuals tell us? What does the premise history tell us about calls for service to the home? Has either individual been involved in domestic violence with other individuals? What's the comparative height and weight difference? And all of these things, the totality of all of them together is what's painting this picture. You know, what kind of history is there with respect to protection orders? Who is capable, who seems more capable of assaulting the other? What kind of threats have happened between these individuals, and who has carried threats out? What kind of injuries do they have? Are they offensive in nature? Or are they defensive in nature? You know, have we done a good self-defense assessment? And what's the potential, you know, if we leave for future injury? You know, who is the bully, right? Who needs protection? Who's acting in self-defense? What are the degree of the injuries? What kind of threats are going on? You know, and again, that history. And you can walk through this matrix, and you know, and really this kind of gives you a guide as to if you have, you know, do you have information from 911 or prior contacts, criminal history, and everything that can really flavor what you're looking at, provide context. You know, did one or more people use violence? If yes, you know, was one in self-defense? If no, do I have evidence for a single custodial arrest, right? And you can work right through, depending on the facts and circumstances you have. The more you have, the better your decision making is going to be. We want to make certain that we aren't engaging in dual arrest or mutual arrest. And that really begins with sound policy, and checks and balances should be in place to ensure that there is adequate, up-to-date, ongoing training. And some sort of analysis should be in place to ensure that the desired outcomes is being accomplished. You know, if you're making a dual arrest, you're saying you have two assaults. Thus, you should be writing 2 reports. And a one report where one party is the suspect on one and one party is the victim on the other. But they should be, because you're saying 2 different events occurred, right? If it's being done, it should be done correctly. I'm not saying that that can't happen, but it should be extremely rare based on the facts and the circumstances, the history, all these things that we're talking about. If you conduct a thorough investigation and you're unable to determine the predominant aggressor, then you really need to assess for the safety of the parties and try to convince the parties to separate for the evening. Petition for a protection order is appropriate. You know, someone doesn't always have to go to jail, and we shouldn't be arresting both parties if we're unable to determine the predominant aggressor. We're not always going to be able to determine that, and you know that in many of these cases it's a dirty shade of gray. Why? Because we can't. The information's unavailable. We tried to get it. We tried to talk to these individuals, and nobody's forthcoming. It's not something that can always be done. Document your decision. You know, if you ask questions and they aren't answered, document that, right? Then it's clear why you didn't do any more and how you did everything you could, given the information that you had. Talk with your prosecutor's office to make sure you're on the same page. As I said, you know, I used to meet once a week with our prosecutor. Ask the prosecutors what they need in the report for the case to successfully go forward. Ask what happens in a dual arrest situation. Ask advocates, both community-based and system-based, what they hear from victims about the types of offensive and defensive injuries that they see or that they suffer. Ask if and why they ever use force against physical force against their abuser, because you know that can help inform us to do a better investigation. Ask what the victim thinks is a positive or appropriate response for a responding officer would be. You know, in summary, in all that we've talked about, it all boils down to a thorough investigation, looking at context and history, self-defense, use of force analyses, and an analysis of injuries, looking at power and control, documenting our evidence and decisions, and really taking advantage of the partnerships that are available and collaborating. There are, I'm going to be leaving you with a lot of resources from the IACP, national resources, and also take advantage of your local resources. All of these slides are going to be provided for you. That's why I went through them quickly, but I want John to be able to really bring this thing to a close before we go to questions.
Well, I did want to give people an opportunity if they have any questions for Dave or any comments at this point. And Dave, you got your contact info next, right?
Yeah.
Yeah, I just want to make sure.
Yeah, so they'll have that as the last slide on both if they go ahead and ask for the slides.
Well, everybody will be sent the slides, so
okay. So yeah, so they have all of that.
Yeah, so if you have any questions or comments, go ahead and chat them. If you don't, Dave, if you want to stop sharing, I'll just jump in and wrap up fairly quickly, because I feel like you've covered most of this. Okay. But please, again, feel free to chime in with any questions for Dave or me at any point. And again, we've talked about a lot of this stuff, the evidence-based strategies. That's just about us. We've got all sorts of stuff. Again, it was both these presentations, or all the presentations you've seen in the last 2 days, were supported by the Department of Justice, the Bureau of Justice Assistance, through this IPS grant. They don't necessarily agree with what we say, but they fund us, and there's fair use. So, as you know, again, we're trying to obtain in these difficult cases, just trying to obtain and maintain the evidence, establish probable cause, be able to prove it with or without the victim's testimony, and whether the victim testifies the way we want. We always want to corroborate the case, which strengthens it, and document the circumstances around the statements or disclosures. because we know that there's a good chance we're not going to have a victim come time for trial, that documentation of the circumstances may provide us the hearsay exception to get that evidence in. Dave talked about this in depth, so I'm not going to go over that again. The one thing I do like, you know, again, it depends how much time and resources, but people should think about one, the historical evidence of the relationship. We want to know about that relationship. That is where these cases live and die. And the other thing I just always like is, if an offender is locked up, are we listening to the jail calls? Because there's going to be valuable evidence in there, and it may be evidence, it may be an apology, it may be a confession of sorts, or it may be evidence that he is trying to make this victim go away, change their story, or not come to court. And we can use all that. Social media may have a lot of good evidence in there, so we definitely want to follow up with that. So as we're thinking about our investigation and what we're documenting and asking about, the things that are going to maybe stop us from getting evidence in is the right of confrontation. Every defendant has the Sixth Amendment right to confront their accusers, and it's an important right. It's the bedrock of our criminal justice system. So the courts and the prosecutors and law enforcement take this seriously, and they should have that right. The courts back in 2004, the Crawford case sort of changed how we were able to get evidence in. And so they divided these out-of-court statements into two categories. And Dave mentioned these previously: testimonial statements and non-testimonial statements. So those testimonial statements, those are statements that can only come in if the victim or the declarant, but we'll say it's going to be our victim in this case, is available for cross-examination at trial, or they were previously available, they're unavailable at trial now and were previously available and were cross-examined on this topic. So that's the only way to get testimonial hearsay statements in. Testimonial, so we'll talk about what testimonial is in a minute. Non-testimonial hearsay, there is no right to confront a non-testimonial hearsay statement. So that's some statement the victim made, but it is not a testimonial statement, it's non-testimonial. The only way to get those in is through a hearsay exception. If the victim is present and testifies, then there should be no issue about testimonial and non-testimonial statements. They can be cross-examined about whatever statements they made. So testimonial statements are those statements that are typically made to a law enforcement officer investigating the case. Give me the facts, tell me what happened. Or if you're doing your trauma-informed response, all of those questions that you're asking about, all of that is going to pretty much come under the category of testimonial statement. And the primary purpose of these statements is to report facts for a later prosecution, right? You're gathering the evidence, you're going to make a charge, and we're going to use those statements that you gathered to prosecute the defendant. And so that's the case where the victim's got to be there typically and has to testify about those things. Non-testimonial statements are not statements that are typically made to law enforcement officers investigating the case, with some exceptions. But typically a non-testimonial statement is going to be those casual remarks to others. It might be a business record that just routinely keeps track of information. It might be a statement made to a medical provider because a victim's being treated for injuries. But those casual remarks to others are the area I want to focus on. Victims who talk to a friend or family member after an assault, they're looking out for support. You can't believe it happened again, or this is what he did this time. Those sorts of statements that they're telling, and that person might even be the one that encourages them to call law enforcement. Hey, you need to call the police right now. Don't risk more harm. The other category of non-testimonial statements that is important, though, is statements that are made during an ongoing emergency. So statements when a victim calls 911 and says something like, my boyfriend is beating me up, he's here now, and he's been threatening me, and he's assaulting me, and you can maybe even hear the boyfriend in the background. Those are typically non-testimonial because they're not statements that are made in that moment to prosecute that offender, to gather evidence for a later prosecution. They're made for that victim to get help, for to aid the police in meeting that ongoing emergency that currently exists. So it could be over 911, it could be law enforcement responding to the scene and the victim runs out of the house, he's got a gun, he's threatening to kill me, things like that. Those statements are non-testimonial. And so the victim doesn't have to be present for those to come in, but we do have to have a hearsay exception to get them in. So documenting the circumstances of how these statements were made that are made to law enforcement at the scene can be very important, because the emergency might be ongoing or has just finished, or the offender might be armed. And you're asking your routine questions to secure the scene. And if that individual is armed, even if they've fled the scene, that is a dangerous situation and that could be an ongoing emergency. So when I know that information, that gives me more arguments to make to the court that these are non-testimonial statements and should come in under a hearsay exception, even though my victim failed to appear today to testify. So we want to think about that. Again, if the victim's there, there should be no Crawford issues regarding testimonial or non-testimonial statements. If the victim is not there, then we need to get those non-testimonial statements in, and we need to have our hearsay exceptions. The main one is going to be the excited utterance, right? That's the one we rely on the most. If the victim's calling 911, if you respond to the scene and the assault has just recently finished, or at least the physically violent part of the assault has recently finished, and the victim's telling you things and you can tell they're upset, your body-worn camera might capture that. They might be trembling, they might be voice quivering, things like that, crying. That's establishing evidence that this was an excited utterance. So we have to demonstrate to the court that this hearsay exception applies. So if victim doesn't come, I can still get that statement in. A present sense impression might be a statement from the victim, or it could be the person that called 911. He's hitting me now. A present sense impression is something that is happening and the person is relaying what's happening as it's happening. Like he's at the 20, he's at the 10, he's at the goal line. You know, it's relaying the information as it's happening, and those can come in. So if the victim is relaying what's happening as it's happening, or if a neighbor is calling in or somebody's calling in, hey, he's got her outside, he's got her by the throat, he's hitting her right now, you need to get here right away. Those statements can come in even if we didn't have that declarant present. Victim statements about things, their current emotional or physical condition. My head hurts where he hit me. I'm very upset from when he had his hands on my neck, things like that. Those can come in. Statements for purposes of medical diagnosis or treatment are typically non-testimonial. That gets a little tricky when we need that statement to identify the person who caused the injuries. And so we have to think about those. But basically, if the statement is testimonial, yes, then the victim must testify or there was some prior opportunity to cross-examine that. If it's not testimonial, then it's just a hearsay exception that we need to get it in. First, we want to support the victim any way we can to make sure that they are available and can testify, and they will need our support in these cases, right? We want to oppose continuances. We want to make sure they have the services they need and that we're working in a coordinated fashion with our advocacy folks, because they're super important to this process. I know a lot of times people think, oh, advocates get in our way. It's the exact opposite. They really help us and improve the victim's ability to participate in the investigation or prosecution. But really questions that I want to ask is, who has that victim talked to about what happened to them or about what has been happening to them in their world? And so is it a friend, a family member, an employer or coworker, their landlord, the neighbor, or a medical professional? If they've gone to the doctor on an incident that they didn't report to police, do we have that historic information that we can get and introduce at trial, because we're able to identify the defendant? Those 911 calls, we want to make sure, or those statements at the scene, we want to make sure we preserve those. Dave talked about that. They're helpful to corroborate. We can typically get those in as excited utterances, so those are good sources of information, and they typically are sort of self-authenticating, i.e. that the victim is still under the grip of the recent incident that caused them to make the statement or caused them to be upset. Sometimes those on the scene statements, as you're doing your investigation, there might be an ongoing emergency, but you're asking other things because you're just doing a thorough job. And so they might sort of become testimonial, like, has this happened before? Is that a question that's necessarily going to help you meet the ongoing emergency? Maybe not. And maybe it's testimonial in nature. That's fine. We'll leave that part out and just get the part that is non-testimonial to come in. On-scene statements to the kids, to the officer, interviewing those kids also is going to be super helpful. The medical treatment, how did the injury occur? Though, was there a weapon used? Was strangulation? Identity of the assailant, there are ways to get that in. The Georgia law is not friendly to that currently, but if you can lay a proper foundation where a healthcare professional can articulate that why they asked that question in a domestic violence situation, or because of the potential for domestic violence, even when a victim hasn't offered up who assaulted them, and why they need that for diagnosis and treatment, then you might be able to get that in. And typically what the healthcare professionals will tell me is that I do need to know that, because I create a plan for victims, discharge plan for victims after I treat them. So I'm going to get their medical history when they come in, so we don't give them anything they're allergic to, or we know what all their history was. I'm going to ask what brought them in today, the history of the assault. I'm going to treat the injuries that they have, and then I'm going to do a discharge plan, which could be get this prescription filled, follow up with your regular doctor, things like that. But for assaults like this, they might also ask, is the person who's causing you harm in the home? And so maybe I don't need to know the name of the person, but I do need to know the identity, because I'm going to give that individual some domestic violence resources that I wouldn't give to somebody who got in a bar fight with a stranger. So it's just the same as if I'm sending somebody home with crutches, I might ask, can you stay on one level, or do you have to go up and down stairs? Because it's pretty dangerous to go up and down stairs on crutches. And so asking that kind of question about their home life is pertinent to diagnosis and treatment in these cases. Your healthcare professional is going to have to articulate that. If they don't, then you're probably not going to be able to get that statement in. If they can, then the court maybe would allow that in. There is a lot of authority from other states to allow that in. I took a quick look at Georgia law, and right now it is not a good landscape to introduce the identity of the assailant via a healthcare provider. This is the question that I think, Dave, if you were going to do that supplemental report, I think you would add some things to it and maybe improve it. This is a question that I think I would add that we should all be asking. It's not just on officers, but all of us. I interview my victims too, and I can ask these same questions. Have you talked to anyone else about this incident, either before or after you spoke to the police or called 911? And the idea there is, did the victim call somebody right after the assault occurred, but before they called the police? Or did they call someone right after they called the police or talked to the police just to get help and emotional support? Those people are non-testimonial hearsay witnesses. I can identify them, subpoena them, and if my victim, for whatever reason, can't make it to court because it's too frightening, or her safety will be so impacted that they're not coming to court, that witness can testify about what that victim told them shortly after or shortly before they called the police, but always after the assault, right? And then I can get that in. So that's what I want to key on. And I want to document any evidence that exists about an ongoing emergency at the time. The last little thing I wanted to touch on is just another hearsay exception that most states have. Georgia has it, and it's called forfeiture by wrongdoing. And it's just if the defendant does something to make that witness fail to appear in court, make them unavailable, as we say, and that it was their intention to make them unavailable, then that victim's statements can come into evidence. Whatever they told the police about what happened during that golden hour that Dave talked about, that can come into evidence if we can show that. And we know this is going on all the time, right? They're manipulating, they're putting pressure on them. It might be calls from the jail. It might be something the victim shares with you. But that's what I want to know about. What is that offender doing to either intimidate or manipulate that victim? And that's going to be important evidence. And then that might be how I get those statements into evidence when my victim hasn't shown. So I want to be always asking about what that defendant is doing after he's been arrested. What's the contact that they're having, whether or not he's prohibited from having contact with them. To get that those statements in, all we have to show is that the defendant did something to make the victim go away with that intent. And we just have to show it by a preponderance of the evidence, which is just more likely than not, as opposed to beyond a reasonable doubt. So that's a huge advantage. You do a little hearing outside the presence of the jury. If it's a jury case, if it's not, the judge can hear it and make a decision. And the judge isn't bound by the rules of evidence. So an officer can testify about what his investigation revealed about the offender threatening or manipulating the victim. I listened to jail phone calls. The jail phone calls are here. We can play them for you, but they essentially say, please don't come to court. If you don't come to court, the case goes away. Don't, I want to go home to see my kids. I want to keep working to support you. I'm going to change. I'm going to get help for my drinking, whatever it is. All those manipulative things, which is more often what's happening than the threat, I'm going to kill you if you come to court. But that happens too. So if we get any of those, we can get those in before the court because they're not bound by the rules of evidence for this hearing. And then once they determine, yep, the defendant did these things, the victim's not here, it's more likely than not they're not here because of what the defendant did, I'm going to allow the officer to testify about what the victim told them happened to her. And so then when you pair that up with all the things you've documented, all the physical evidence, all the photographs, all the other things, we have a good case and we can still go forward in these situations. All right, so I zipped through that just because I didn't want to belabor it, and I feel like Dave covered a lot of that stuff. So I just wanted to make sure that you guys are aware of those handful of additional legal hearsay exceptions and how that works and why we need all of that thorough investigation, why we need to document it, even if I can't get it in. One of the key legal exceptions that allows us to get in prior crimes and other acts is that 404B, prior crimes and other acts section. And all of these things are going to be helpful to know. Some of the things that allow me to get that evidence in of prior assaults, which really helps my current case. If I can show this has happened again and again and before, if it demonstrates the defendant's motive to harm the victim, if it demonstrates a lack of accident, if that's them to say, oh, she's clumsy. She just hurt herself. She fell down. Well, it's happened 4 times before this, that same accident. I don't think so. So that might demonstrate that there was a lack of accident, the identity of the assailant, things like that. All of that information is super powerful, super helpful to get me in. I still go back to what Dave talked about yesterday and just that trauma-informed response and collecting that trauma-based evidence of what was going through your mind. I really think that you're not going to hit gold every time, but that's really where you get really powerful evidence that can come in and really demonstrate to the court, the judge or the jury that, look, this really happened and this is how bad it was. So just to top off on what Dave has talked about over the last 2 days, this is what I see as how I can improve my ability to go forward in these cases and get convictions. They're really tough cases, as you guys know, and we don't get convictions in every case, but that's not mean we didn't win, because how we treat victims, how we shine lights on offenders, and how we improve the system's response are all victories, I think, in all these cases. And we're going to win more. We're going to try more cases and we're going to win more cases if you take this trauma-informed approach and collect this evidence, document it. I think it's just going to improve the response overall. I went pretty fast. Does anybody have any questions or comments on that? And again, you're going to get those materials as well. And you're welcome to reach out to Dave or myself anytime for any of this stuff. If that second John Wilkinson is actually Alicia, I was gonna just say, Alicia, I don't know if you're there, but if you have any final comments, or I'll go to Dave first. Dave, if you have anything you want to wrap up with.
No, just reach out if you all need anything. It's a lot of information in a short amount of time. So as you go forward, get the slides. You have any questions, you'd be more than happy to clarify stuff for you or give you any technical assistance that I can.
And I just would echo that. Thank you guys for attending, paying attention. The comments were great. And thank you, Dave, because that was great information. I just put together so well. And then Alicia is also saying, thank you all in the comments. And hopefully we will be getting together again in the future for additional training. And if anybody needs anything, or you'll be welcome to share the information we send with anybody you want. But again, please reach out. Thanks, everybody. All right.
Be safe.
Be safe, everybody.